is that we are all still alive out of all these things that are happening outside. And God is always good at all times. I would like us to open this meeting by bowing our heads where we are, so as to just thank the Lord that has kept us till today. Let's do that. Thank you very much, honorable members. I've wished to welcome everyone during this month of the Youth Month, where we are supposed to honor the youth. Even the children are still the youth. So as social development, we have a responsibility to honor and I will say be very cautious in terms of whatever that is happening in our surroundings. We know that even today, there's still, I will say, a GBV. They are killed. The kids are being killed. They are being kidnapped. And we always wish that if that can stop with immediate effect in our country, we'll be very, very happy. And as the committee, we definitely wishes all the kids to be safe in our hands during our era, but really people outside started to be animals and don't immediately, we'll say, pamper and comfort our kids. But let's keep on, and we must not give up. We must do our best in terms of doing these awareness campaigns where we stay in our areas, around our families, but we must keep on, soldier on, and make sure that we protect our children, our youth, even the elderly. We have to see to it. I wish to welcome everyone in terms of, I'm not sure whether the minister and the DM has joined us. If they have joined, I wish also to welcome them, even the staff, the officials, whoever is a visitor, the stakeholders. Good morning to everyone. Let's not waste time, but get into the gist of the day. So I will request Lindy to flight our agenda for today.
Thank you very much, Chair. Good morning, Chairperson and members and stakeholders with us. Here is the agenda of today's proceedings. Thank you very much, Chair.
Thank you very much, Lindy. Honorable members, the meeting agenda is welcoming and opening. The second one is the roll call that we used to say. Lindy must confirm, and yes, she must confirm who is in attendance, and we'll get into the apologies after we have done with the roll call. Over to you, Lindy.
Thank you very much, Chair. I wish to confirm the following members of Parliament that are in attendance of this meeting. We have you, Chairperson of this committee, Member Mbana. We have Member Manganye. We have Member Motaung. We have Member Pilankulu. We have Member Stock. We have Member Mare. We have Member Shongo. We have Member Abrams. We have Member Eris. We have Member Fana Merve. We have Member Priet. We have Member Sukars. We have Member Masango. And the last member is Member Operman. So I wish to confirm, Chairperson, that we are a full house. All members are here, and then we can take decision as we are a quorum. Thank you very much, Chair.
Thank you very much, Lindy. We appreciate that understanding that people have also other commitments. but they have prioritized this committee. Thanks ever so much. If it is the case, let's also allow the next item.
Chair,
Or let's go to the department first. Let's go to the department first. Who is the head
Kumbula,
today?
Chair. I think the acting DG,
Okay.
Mr. Kumbula Daba, his hand is up, Chair. Maybe he wants to say something.
Okay. All right.
Good morning, Honorable.
Mr. Daba.
Good morning, Honorable Chairperson and
Morning.
Honorable members. May I apologize for both the Minister and the DM. They are out of the country on business. The DG is also not available. He's in a meeting, the Presidential Coordinating Council. He is going to join this meeting a bit late. The rest of the team is here with us. We are ready. So if the meeting can accept those apologies. Thank you very much.
Okay, thank you very much, Mr. Daba. We were still going to go to the apologies, but thank you very much to be proactive and tell us that the minister and the deputy minister are not available, so that we don't give them that opportunity to have a political overview. Lindy, can we get to our apologies from the side of the honorable members?
There's none, Chair. All members are present.
Yo,
Yes,
thank
Chair.
you very much. Thank you very much. Then let's go to the adoption of the agenda, honorable members. But yes, the agenda is as follows: consideration and adoption of the A-list clause, the Children's Amendment Bill, and then after that, we will get to the deliberations and the adoption at the end of the day. Then we'll have to do our minutes as we usually do. We do minutes of the 25th, and then after that, we will go to, in fact, we'll close the meeting. That's the agenda of today. Can I get anyone to adopt the agenda as it is?
Member Hlongo, hands is up, Chair.
Okay. Mhlongo, Honorable Mhlongo, over to you.
Thank you very much, Chair, and greetings to honorable members. I move for the adoption of the agenda as presented.
Thank you very much. I can see the hand of Honorable Stock.
Thank you very much. A very good morning to all honorable members and the officials in the platform and the stakeholders as well. A very good morning to all of you. I second the proposal for the adoption of the agenda. Thanks.
Thank you very much, honorable members. The agenda has been adopted as it has been proposed. Then let's go to the business of the day and get the legal advisors to tell us today on how far are we, because we understand that now we are on the A list. We still have to go to the B list. We still have to go to the second phase of the other acts or bill, which we haven't finalized and finished it for now, because we have tried to break them into phases. We start with this one, we'll go to the other phase. Then also the legal advisors, after we have done the A list, they will tell us the plan for us to go to B list, and then they will table the plan and they will tell us on how far are we and how are we going to go about with going to other clauses that we haven't managed to finish or finalize in this phase. Thank you very much. Then legal advisors, whom are we having with us? Parliamentary advisor, are you with us?
Good morning, Chairperson. This is Natim Jenglana, the Parliamentary Advisor. Thank you, Chairperson. I'm with you. And I'll be presenting the A-list to the committee this morning. Thank you.
Recording in
Okay.
progress.
And is there Mr. Advocate Mchochisa, the one from the department? Mchochisa. Oh,
Honorable Chairperson, Mr. Mchochisa is also in the meeting.
okay. Is there the State Law Advisor's Office present?
Morning, Chair. I'm also present.
Thank you very much. Then it means that we are on the safe line. Who's going to start between yourselves? Because you have to definitely have a bite and input on this before we move on.
Chairperson,
Yes.
Chair, can I just try to provide some guidance and procedure on the matter? The stage
You are welcome.
the stage we are at now is the bill is before the committee. So the leading person as far as the guiding the process is the parliamentary legal advisor, because the matter is no longer in the hands of the department. The department play a minimal role as far as advice is concerned. So the leading person is Mjenglane Chair and the State Law Advisor. Thank you very much. But if you want to verify something, so I just wanted to give that clarity that Mjenglane is the key person now that the bill is before Parliament. Thank you very much.
Thank you very much, Lindy, for putting us in a clear perspective of what is it that is supposed to happen. So there's no need to ask who's going to start, unless otherwise there is something that we would like to clarify and get it from the department.
Yes, sure.
Can we give over to Mr. Mjenglane?
Yes, Chairperson, thank you very much for the opportunity. Good morning to you, Chairperson, the honorable members and my colleagues.
Morning.
Thank you, Chair. Chairperson, this morning we are going to be presenting the draft A-list to the committee. Chair, I just want to, with your indulgence, just say a few introductory remarks regarding the issue of the A-list or the stage where the committee is at. Chairperson, we have been advising the committee in respect of this amendment from when the bill was introduced, the time that the committee engaged in public consultation. So in respect of the public consultation, Chair, I would just like to make a comment in response to your question when you were doing your introductory remarks in respect of what the decision the committee has taken in respect of this bill. That's by way of reminder, Chair. The first decision that the committee has taken was to remove the ECD clauses on this bill, as the function was being migrated to basic education department. So that was the first amendment that the committee made in terms of this bill. The second proposed amendment by the committee was to focus on those clauses that are going to provide for comprehensive foster care parenting in line with the North Gauteng High Court decision. So that's the second decision that the committee took. In respect of both the decision, the committee asked for legal advice from us, legal support. We provided the legal support, but the decision in respect of what was to happen in respect of the bill was that of the committee, as in line with the constitution and the rules, that legal advisors themselves do not make decisions. It's the committee itself that makes decisions. So the committee then made that decision and the bill was separated. The decision of the committee in respect of the rest of the clauses, Chairperson, in this bill, which do not relate to foster care parenting, was that technically they are going to be rejected. Chairperson, when I use the word technically rejected, I am referring to a technical legislation drafting mechanism of effecting the committee's decision on the bill. Rejection in respect of this, Chairperson, must not be misunderstood or understood to mean that all of the work which has happened in the committee in respect of this bill is completely rejected. Because the decision of the committee in respect of that matter is that the rest of the clauses of the bill which do not relate directly to foster care parenting are going to be kept in abeyance, meaning they're going to be suspended for this amendment period whilst the committee focuses on foster care parenting in line with the Gauteng High Court judgment. However, all of the work which has been done by the committee in respect of this bill, including the public consultation, very extensive public consultation that the committee undertook, will inform what the committee has decided to do with this bill, which is to initiate a committee bill in line with what the Constitution gives the committee, vests the power on the committee, including the National Assembly rules. The committee has decided that it will take the rest of the clauses, and including all of those clauses which have been discussed here by members, and put them in a committee bill, which committee bill will be considered by the committee. Chair, the rules of the National Assembly provide extensively for that process, the process of the committee bill. It is a process that is provided for in Rule 273 of the National Assembly rules, where it says that the committee must seek the permission of the National Assembly in terms of Rule 2681 to table a committee bill. And when the National Assembly Speaker gives that authority, the committee bill, which will be formed of all of the clauses that are not forming part of this foster care parenting in terms of this amendment process, will form part or will consist of that committee bill, which will be put on the order paper as soon as the authority to do so has been granted by the National Assembly Speaker. And then the similar process which is undertaken in the committee in respect of this bill will follow, meaning the bill will be tabled before the committee will consult again on the bill, possibly not as far and wide as it already did because it has that input already from the public, which input is in the form of the matrix that is currently before the committee. And all of that information will inform the committee process when the committee is considering the committee bill. In respect of this, Chair, I just want to also state that this process, Chair, is provided for in the Constitution as well as in the rules. And if it is in the members' interest, I can refer to specific sections of the Constitution and the rules that allow the committee to do or decide what it has decided, which is to amend the bill in the manner that it has decided. So, Chair, coming to today's business, which is the issue of the A-list. The A-list, Chairperson, the name A-list is just a technical term for drafting purposes, which is an instruction to us legal advisors to go and list the committee amendments. The committee amendments in respect of this matter, Chairperson, are those amendments which the committee, through its deliberation and decision-making, has directed us as legal support to go and effect technically and bring back to the committee to consider whether what we have done reflects its decision. And therefore, in respect of this amendment, Chairperson, the decision of whether the A-list reflects the decision of the committee is a matter that will be decided by the committee when we table the A-list today. Thank you very much, Chairperson, for indulging me in those introductory remarks. And therefore, I will ask Lindy to please help me to put the A-list on the screen for members so that I can just go through it and present it to members. Thank you. Lindy, can you please just share on the screen the draft A-list for members? Hi, Lindy.
Everybody,
Yes.
this one.
He is busy.
Yes.
He's busy doing it.
Thank you very much, Chair. Thank you very much. Thank you very much, Chair, and thank you very much, Lindy. If you could just close the box on the left.
Okay.
Thanks very much. Chairperson and honorable members, this is the A-list that we will be presenting today. Just quickly, Chair, for reference purposes, I would just like to remind members that they have before them the necessary reference documents, because there's going to be a lot of cross-referencing, because this work, which is the work of listing committee amendments, is quite a technical drafting process. So the reference documents that I would recommend for members to please have in front of them as we're going through the A list are the following very key documents. It's the Principal Act, which is the Children's Act of 2005 that is being amended. It is the bill as introduced. So the bill, the original bill as introduced. It's this draft A list that we're presenting. It's also the matrix, which is the public commentary and responses from the department. Members may also have the list of amendments that we had proposed in drafting, which reflect what is now going to be considered in the A list, and which we, in our view as legal advisors, both myself as a parliamentary legal advisor, as well as a state law advisor, including the department's legal advisor, have agreed that we technically, when we are looking at the bill as introduced, these clauses would be the ones that are relevant in order to provide for foster care parenting. And that matter was put before the committee, deliberated on, and now we are going to be putting on this list, Chair. So, Chairperson, the A list reads as follows, Chair. It's the Portfolio Committee amendments to the Children's Amendment Bill, B18 of 2020. These amendments are as agreed by the Portfolio Committee of the National Assembly. So the first amendment, Chair, is the amendment to clause 1 of the bill as introduced. So, Chair, when I read the first amendment clause, it is on page 2 of the bill as introduced. So on page 2, in line 15 of the bill as introduced, after the word, after comma, we insert comma if applicable. So after the word has, here in line 15, after the word has, we include the following word, comma, if applicable, comma, and close inverted commas. So that comma, if applicable, comma, will be the words that will be added in that sentence, which is on line 15 of the amendment bill. So on the same page, Chair, from line 19, the definition of adoption service will be omitted. And then, Chair, we go to the next page in clause 1. The next page is page 3, from line 7. From line 7, the definition of aftercare will be omitted, Chair. On the same page, from line 16 of the bill as introduced, the definition of care is being omitted. And on page 3, Chair, from line 23, we're omitting the definition of caregiver. And on page 3, from line 24, we're omitting the definition of circumcision. On page 3, from line 27, we're omitting the decision of clerk of the court. And on page 3, from line 37, we're omitting the definition of divorce court. On page 3, from line 38, to omit the definition of early childhood development center. And on page 3, from line 43, to omit the definition of early childhood development. On page 3, from line 50, to omit the definition of family counselor. And on page 3, from line 55, we omit the definition of genital mutilation. And on page 4, which is the next following page, Chair, we'll omit the definition of inter-country adoption. And on the same page 4, from line 8, we omit the definition of midwife. Can you please go up for us, Lindy? On the same page, Chair, the definition of nurse is omitted from line 11. And on the same page, the definition of party is omitted from line 16. And on the same page, from line 21, we omit the definition of regional court. Page 4, we omit from line 24 the definition of separated migrant child. Same page from line 30, we omit the definition of sexual abuse. Same page from line 34, we omit the definition of social service practitioner. On page 4, from line 42, we omit the definition of temporary safe care. Page 4, line 51, we omit the definition of unaccompanied migrant child. And we also omit the substitution of subsection 4. So, Chairperson, this is clause 1. What we have reflected on this clause, Chair, just to remind Chairperson and honorable members, is those clauses that are going to be removed from the bill as introduced. When we have the B version of the bill, which is subsequent to the deliberation by members and decision on this one, it will reflect all of these clauses having been removed from the bill. And those which are not on the A list will remain in the bill. So we have kept the 3 clauses as had been presented before members. They will reflect in the B bill, which will be presented to members. Chairperson, that is clause 1 of the A list. I will be guided by you, Chairperson, whether I need to go through the entire A list or it is just going to be a matter of me reading the one clause and the members deliberate on it.
Hello, you are
Yes,
saying
Chair.
you need to get a direction. I think one can present the A list, and then honorable members are noting what they think they need to clarification and also deliberate on it. So without hampering and disturbing you, why don't you proceed? Because we're listening and we're having pens and papers. We are noting all what you are saying. Carry on. Clause 2.
Chair, maybe there's a technical glitch. Let me try to phone him.
Okay. There's a technical, and also I can see from the chat. I know for a fact the advocate is a fast speaker. If he can low down the speed so that people are able to capture exactly what he is saying. However, the speed, if he can slow down the speed and not be fast. Lindy?
Chairperson and members, the system kicked him out. She's trying to log in. I've conveyed the message about the speed when he speaks. Yeah, he's trying to log in again.
Okay.
Sure. Okay.
Lindy? Lindy?
He's trying to log in. I just spoke to him. I think he's got the network problem.
Yeah.
But he's trying to log in. Maybe in a minute's time, he will join. Yeah, he's just joined, Chair. He's coming in now.
Honorable Nhlongo is also encountering this technical glitch in terms of the network, but she is going to rejoin and rejoin. So please accept them when they rejoin.
Thank you, Chair. I'm back on, Chairperson. My apologies to you and honorable
Oh,
members.
Lulu is back. Over to you.
Thank you, Chair. And we had just completed clause 1, Chairperson, and I have noted your advice, Chair, that I need to be a bit slower in presentation. So Chairperson, the A list from clause 1 reflects what we had spoken about when we were doing our introductory remarks, Chairperson, which is the decision of the committee to reduce the bill to those clauses that are focused on foster care parenting. And therefore, the clause 2, which says clause rejected, is one of those clauses that are going to go and form the committee bill, which I had advised on, Chairperson, when I started my presentation. So those are the clauses that will be dealt with in terms of National Assembly Rule 273, which is the process of developing a committee bill for these clauses. The same will apply, Chairperson, to clause 3. So when I mention these clauses, Chairperson, these are the clauses in the bill as introduced. In this list of amendments, we are effecting what the committee has decided to cut the bill and keep the others in abeyance and only keep those clauses which are relating to foster care. So the same with clause 3, Chairperson, is being rejected, technically taken in abeyance. Clause 4 is the same, Chair. Clause 5 of the bill as introduced, also clause 6, clause 7, clause 8, clause 9, clause 10, clause 11, clause 12, clause 13, please go up, Malindi. Clause 14, clause 15, clause 16, clause 17, clause 18, 19, 20, 21, 22, 23, 25, 26, 27, 28. Members, I just want to explain that where we have skipped a clause in the clauses as rejected, it means that the clause will remain as is in the bill as introduced. So that clause will be taken directly from the bill as introduced and it will go into the B version. But members will have a clearer look when we are presenting the B bill because it will reflect all of these amendments that the committee has made. So there's
will you please repeat yourself on this one?
Chairperson,
clauses that are rejected.
Thank you, Chairperson. Chairperson, I said we have used the word rejected here. Technically, it is a legislation. Yes, Chair. So these clauses which have been rejected are the ones going to be kept in abeyance. So, but now I was saying, Chairperson, where we have skipped a clause, for instance, where we are not following with 27 and 20, if you go up, Malindi, can you please just go up a little, Malindi, just for explanation? No, please, around clause 20, Lindy, please.
Yes.
So just for the purpose of explanation, Chair, I was saying that if we don't have clause 24, for instance, we have 23, we say is rejected, and we say 25, and 24 doesn't form part of this list. It means that 24 is a surviving clause, Chairperson, technically. It's those clauses that relate to foster care parenting. They will be reflected in the B bill. And the B bill, Chairperson, is the bill that will incorporate these changes that you've made here, as well as the surviving clauses in the bill as introduced, which is the bill that will be the final bill of the committee.
Okay.
Thank you, Chair. So we are in clause 26, which is rejected. Please go up for us, Lindy. Thank you. Clause 27 is rejected. 28, 29 is also rejected. 30, 31, 32, 33, 34, 35, 36, all those clauses are rejected, going into the committee bill. Clause 37, 38, 39, 40, going into the committee bill. 41, 42, 43, 44, 45, 46, 47, going into the committee bill. 48, 49, 50, 51 kept in abeyance and technically rejected in this list. 52, 53, 54, 55, 56 is rejected. So when it relates to clause 56, Chairperson, just a bit of explanation how we have done the technical drafting here. We have rejected the clause 56 as it appears in the bill. The reason for that, Chairperson, is because we had to consider the public input that is in the matrix, as well as the discussions of the committee, and effect that in technical legislative drafting language. In order to do that, Chairperson, we collapse the 56 as it reflects in the bill.
Slow down the pace.
Oh, my apologies, Chair.
Very fast when you speak.
Yes. No, my apologies, Chairperson. I will go a bit slower. So I was explaining the technical drafting process that has taken place in clause 56, Chairperson. So in that explanation, I was saying, Chair, there is clause 56 in the bill as introduced. And that clause 56 is one of the clauses that form part of the foster care parenting as decided by members.
Yes.
So we then considered the matrix, Chair, which is the list of public input in respect of that clause. We also considered the departmental's responses to the public input, as well as the deliberations of the committee in respect of this clause. We then collapsed or rejected the 56 in the bill, Chair, in order to technically give effect from a legislative drafting perspective, effect to all of these reference documents and information that we considered. And then we introduced a new clause, Chairperson, which will now be our clause 2, technically of this list of amendments. So this is how 56 looks like now, Chairperson. It reads as follows. So clause 56 is an amendment of section 105 of the Act. We are inserting the following clause, Chair. Section 105 of the Principal Act is hereby amended by the insertion after subsection 5 of the following subsection. This is the new addition. And it's going to be subclause 6. The department must, as prescribed, develop and conduct a quality assurance process for the evaluation of A, child protection services, and B, child protection organizations as contemplated in section 107. So, Chairperson, that is now the technical drafting we have done to give effect to the public input, the responses of the department, the deliberations of the committee. We then went and did that technical drafting in that clause. Going on, Chairperson, in clause 57, it was rejected. 58 was rejected. 59 was also rejected. 60 was rejected. Clause 61, 62, 63, 64, 65, 66, 67, 68, 69, 70. All those clauses, Chairperson, are part of the clauses that are going to be forming the committee bill. 71, 72, 73, 74, 75, 76, going into the committee bill and rejected technically in this process. 77, Chairperson, it doesn't form part of this, in line with my earlier explanation that it is going to form part of the B bill. It's a surviving clause, but it's not amended. Therefore, it's taken directly from the bill as introduced. 78 is rejected. 79, 80, 81. Those clauses, Chairperson, are clauses going to the committee bill. So from 82 to 84, those clauses are not here, Chairperson, because they are going to be taken directly from the bill. They relate to the foster care parenting. They'll be taken directly to the bill and they will go into the B version, and they will reflect better in the B version, which will include all changes. And then in respect of 85, Chairperson, clause 85, we have made the following changes in clause 85 of the bill. In line 50, we've omitted the words less than, and we've inserted the word the words or less in that clause. So the words less than in clause 85 are removed, and we have inserted after the word age in that line 50, we've inserted the following words which are in quotation marks or less. So that's our new clause 85, Chair. And then in clause 86, please go up, Lindy. That clause 86, Chairperson, also in line with the explanation I gave earlier, is a redraft of the clause 86. So the one that is in the bill as introduced has been collapsed in order to give effect to a proposed clause. This we are just putting to the committee as a drafting technically from our perspective that incorporates the public input, the responses of the department, deliberations, and other information that we considered as we're drafting technically. So that's a new clause 86, which we've proposed from a drafting perspective, Chair, giving effect to all of the discussions and the instructions of the committee to us. It reads as follows, Chair. It's an amendment of section 59 of the Act. Section 159 of the Act is hereby amended by the insertion after subsection 2 of the following subsections. 2 capital A. A court may extend an alternative care order that has lapsed or make an interim order for a period not exceeding 6 months on good cause shown. 2 capital B. Notwithstanding the amendment to section 151A, an order placing an orphaned or abandoned child in foster care with a family member in terms of section 156 before or on the date of this amendment act, may be extended by the court in terms of section 159 subsection 2 or section 186 subsection 2. So that is the new proposed clause 286, which gave effect to the public input, as I've indicated, Chair. And then clause 87, Chairperson, is rejected, going into the committee bill. Clause 88, the same, 89, 90, 91. Those clauses going into the committee bill and rejected for the purpose of this amendment process. 95, 96, 97, 98. Members noting that those that are not appearing, the numbers, it means those are surviving clauses. 99, 100, 101, 102, 103, 104, going into the committee bill. 105, 106, 107, going into the committee bill. 108, 109, 110, 111, all rejected to go and form part of the provisions in the committee bill. 110, 111, 112, 113, 114, 115, going into the committee bill. 116, 117, 118, 119, 120, 121, 122, 123, 124, 125. All those clauses forming part of the committee bill and rejected in this amendment process. 126, 127, 128, 129, 130, 131, 132, 133, 134, going into the committee bill as decided by members. 135, 136, 137, 138, 139, 140, 141, 142, 143, 144, 145, and 146. All those clauses, Chairperson, going into the committee bill in line with the process as we have outlined that will be guided by Rule 273, read with 268 of the National Assembly Rules. And then, Chairperson, there is this new clause. This clause, Chairperson, we are putting it before members for members to reflect on it. It's a consequential amendment, Chair. Can you just please go up, Lindy? This consequential, thank you, Lindy. Just please go down a bit. Just one down. Hi, Lindy. Yes, thank you. So this consequential amendment, honorable members, is on section 160 of the Act. This section does not form part of the amendment bill, Honorable Chair and members. It has come to us technically as drafters, and it is allowed by drafting convention that as a consequence of consideration of drafting, that you look for the best way in order to capture an amendment. And in respect of this one, Chair, we as technical drafters, after consultation and considering public input, because this came as a result of public input, consideration of the public input in the matrix, that the best way to amend this section, Chair, was to provide for the quality assurance, Chairperson, the quality assurance procedure, that it be best provided for in the regulations, where the regulations would expand on how the quality assurance process is going to be undertaken. Chairperson, this is in line with drafting convention, because drafting convention says that you may not provide a detailed process or procedure in the Principal Act. In the Principal Act, you provide for the principle and then the operationalization of that principle in terms of the detail, the process. You provide for that in the regulations, which is the delegated power. The Children's Act, Chairperson, is drafted or designed in such a manner that each of the chapter in the Act has a power to make regulations to operationalize that chapter. Now, in respect of the issue of quality assurance procedure, the power to make regulations in that chapter is in section 160. Now, the reason that we as drafters, Chairperson, came to a decision that we would propose this as a form of giving effect to the public input, which the department also agreed to, was that in 160, we would add a new provision, which is the 160 is the power to make regulations for that, for the relevant chapter. And that we propose that we would put in this clause, Chair, which reads as follows: a new C capital A, that the procedure, comma, form and manner that a social service practitioner must follow when assessing, screening, investigating, or referring to the relevant authority and placing a child who is in need of care and protection. So we thought that we would, with the best way to do it, Chairperson, would be provide for this, the amendment in once. It's a consequential amendment, Chair. It does not extend the application of the legislation or extend the application of the bill. It merely provides for proper operationalization of the chapter that is relevant in respect of the quality assurance procedure, Chair, in foster care parent. So that is a proposed clause, Chair, that we thought we would put into the committee for consideration. After that, there is the issue of the long title. The long title has had to be amended. The long title is introduced to reflect all of these changes that the committee has decided on, which is the issue we spoke about of taking some of the clauses and putting them in the committee bill and focusing this amendment process on foster care parenting. So in that long title, we've rejected, the long title is introduced, and we've proposed the new long title. So that Chairperson, is the long and short of our list of committee amendments arising from the process as I have described. So Chair, in this process, I have worked quite closely with the State Law Advisor's Office in the form of my colleague Lisa Naidu, who's in the meeting, as well as Advocate Luyanda Mchochisa of the Department of Social Development, as technical drafters, Chairperson, also comparing notes and relating to the decisions and the deliberations of the committee, and also the public input as well as responses of the department as reflected in the matrix, and all other relevant information for reference from a technical drafting perspective. So thank you very much, Chairperson. That is the list of amendments as directed by the committee. Thank you.
Thank you very much, Mr. Mjengane. I think you are loud and clear, especially when you try to slow down your speed. But I just want to check, I'm going to give over to the honorable members to interact with the A-list. But I'm checking with this one of the one that is section 160. You are saying we have to consider it. When you say we have to consider it, does it mean that it's gonna be kept in abeyance even itself and be dealt with when we do the next phase? Or does it mean also we have to deal with it right now? Then if you can answer me on that one, so as to be able to give over to honorable members.
Chairperson, thank you very much for that question. The clause that we are talking about, Chairperson, forms part of the amendments of the committee today. It's directly related to foster care parenting. So it's to be considered together with the rest of the clauses as listed in the draft A list, Chairperson. Thank you.
Okay. Okay. You still have a long way to go because
Yes,
there's still a lot of clauses that we haven't dealt with it, but it also assists us in terms of trying to rephase and put it in phases, this thing of the children's bill. What were you going to say?
No, Nkosi Chair, I wanted to request, Chairperson, the reason I mentioned the team that I was working with, Chair, I wanted to find out if there is anything that they might like to add in respect of the presentation, just to properly contextualize what we have done, Chair. So if I have in any way left any information that my colleagues think is important for members to consider, I wanted to request your indulgence, Chair, that you allow them to maybe comment on the presentation so that the members can ask questions of clarity.
Yeah, thank you very much for reminding me about that, because even before we get into the details of it, we have to make sure that we give them chance and opportunity to say something. Can we give over to the State Law Advisor's Office?
Yes, Chair. I am in agreement with my colleague, the Parliamentary Law Advisor, Nati. But before we go on, I want to once again stress that this A-list is a working document and the ultimate decision lies with the committee. This document is now meant to be deliberated on. It can be changed, it can be amended, subtracted, certain clauses, or added. So that's entirely in the hands of the committee at this stage. Thank you, Chair.
Thank you very much, State Law Advisor's Office. Then what we need to do now, I think the department doesn't have anything to say for now, as we know that it was from the department all this. But I don't want to close anyone. Anyone outside, but I would love to say, let's give over to the honorable members to discuss this now. Can I give over to them? Can we request the honorable?
Chair, we can't hear you.
So to deliberate, they must switch on their videos because we are live, And then if you have any technical glitches, then you can switch it off. But can we request all the members to switch on their videos so that when we give them time to speak, they are on? Even myself, I don't know what's happening. Thank you very much, honorable members. Can we follow that sequence?
Good morning, Chairperson. Morning, Chair.
Yes. Morning, Honorable Masango.
Morning, Chair. I didn't hear the sequence because the chair was
given.
I didn't hear it, Chair.
The chair was muted when
I also didn't hear it.
Oh, is it? Okay. Yes. I was saying we will start with Honorable Masango and then followed by Honorable Letitia, Honorable Alex, and then Lizelle. I will also remind you when you have forgotten who follows next. But let's start with Honorable Bridget and then followed by Honorable Letitia and followed by Alex. Can we stop there?
Thank you, Chair.
I requested you to switch on your videos because we are live.
Okay, Chair, may I just ask that I switch off my video now because I was struggling to even connect due to the bandwidth that is not very strong at the moment. Thank you, Chair. Then thank you to Advocate Mjengane for the presentation of the A list. What I would like to raise is the clauses or the clause that I believe we should deliberate on and consider not rejecting it. I would like, for example, Chairperson, to object to the rejection of clause 10, which is the section 21, because my objecting to the rejection is because of this clause, the need for this clause to be included with the amendments that were agreed to by the Department of Social Development in response to their public submissions. I would also like to motivate that this amendment is particularly important for maternal orphans in the care of unmarried fathers. So the reason why I'm then objecting and placing it before the committee to reconsider the rejection of this clause, even though we know that all the other clauses are going to be are not completely rejected, but are put in abeyance for the committee bill. But I believe very strongly that this amendment is particularly important for maternal orphans in the care of unmarried fathers. And Chair, another clause that I would like to be read, even if that's possible, if the advocate could read for us section 24 of the Children's Act, please. Because I would like to sort of clarify what it is that I would like for the committee to consider, if that's allowed, Chair.
Thank you. Can we then go to Letitia?
No, Chair. I'm asking for Advocate Mjengane to read section 24 of the Children's Act to us.
There might be another section that that members would like us to read. So we have noted that you want section 24 to be read. And also you have this thing of section 21. So we have noted it. It's rather to give members all the comments and whatever so that he includes everything when he wants to respond. Can we then go to?
Okay,
Lady
Chair,
Shaka?
then can I just say why I would like it to be read, or is also that not allowed at this stage?
Okay.
Because the reason why I was asking that is because I would like to point out that Section 24 says that only the High Court can hear guardianship applications. So what I would like to ask is why Section 45, which is Clause 24 in the bill as introduced, is being amended to give the Children's Court jurisdiction to hear guardianship applications, while Section 24 is not being amended. I would like to ask why the necessary consequential amendment is not being made to Section 24 of the Act. Thank you, Chair.
Okay. Okay, we've noted and said. Okay, the following honorable members. Honorable
Yeah.
Lady.
Yes, thank you very much, Chair. I would switch off my video because my network is
We
not so
haven't
good.
seen you. You haven't seen you. Just switch it on first, then switch it off.
I'm here, Chair.
Yes.
Okay.
Yes, thank you. Switch it off.
No, it is still me, Chairperson. Yeah, thank you very much, Chairperson. Chairperson, mine is just that I am worried with the shortage of, with the inclusion of sections 160, with the shortage of, that we are facing with social workers, that this amendment could force relative scarce and we know that we have approximately 700,000 orphans that need to be assessed by a social worker before they can apply for this child support top-up grant. But not only that, Chair, it can also hinder the comprehensive legal solution to the foster care crisis. And that is due to the fact that we have a shortage of social workers. So I just want to check that for this clause 162 being, implemented, what are we going to do in terms of our shortage that we are currently facing with these social workers? It will definitely make it impossible for the department to implement the child support top-up. Thank you.
Thank you. Noted your concern of shortage of social workers in line with Section 160, Lady. And then
Good morning, Chair. Can I proceed? You muted, Chairperson.
thank you very much, Alex. We are able to see you. Carry on or continue.
Thank you, Chairperson, and thank you to the advocate for the presentation. I believe it went a lot smoother than before, so I do appreciate that. Chairperson, I would just like to start with clause 1 and the definitions. So in the table bill, the one that's 70 odd pages long, some of the definitions like intercountry and sexual abuse and separate migrant child, that was introduced as then substitutes or replacing or redefining definitions. However, now we are completely deleting some of these definitions when it was introduced as just being, changes and adding to definitions. So I would just like to know why have we now completely deleted some of these things, which is then, not as in it was tabled. Then, Chairperson, I would just like to agree with the Honourable Masango on clause 21. And then it's my understanding that all of the surviving clauses we are going to debate in the B list, and therefore I'm not going to get into the questions I have for the surviving clauses, but I do have many. But then, Chairperson, just to go on to section 160, I'd like to confirm, and maybe this is more a question for the department to answer, are all of these not already existing in our child and care and protection policy. Is the policy then vague on this, that we now put in this clause into the Act as a new clause? And then, Chairperson, just a comment on what the Honourable Letitia Ari said about social worker and capacity. I think that is operational requirements. And I do know we must keep operation in mind for when we create in legislation. But legislation should not, how can I say this? There's a need for more social workers, yes, but the legislation almost needs to be separated from what our operational needs are. And operational needs would then have to be implemented at a later stage, if I'm making sense. So this is the laws in a perfect society that we have all the social workers required, because that's what we actually need. And then operationally we have to look at increasing social workers. So those are just my comments for now, Chairs. And like I said, the surviving clauses I do have questions on, but my understanding is we discussed that in the B list. So thank you, Chairperson.
Thank you, Alex. I think we have also tried to cover Letty's consent in terms of operational and also legislation. But we'll allow the advocates to answer that and the state law advisor. Gisela? Oh, before Gisela, it's Lizelle, Honorable Vandameve, and then it's going to be Honorable Opperman. And
thank you so much.
Yeah, it's Honorable Sukers, then followed by Honorable Tehang.
Thank you so much, Chairperson, and greetings to all the colleagues. And thank you very much to the legal team for the presentation. And in particular, I really appreciated the comment from the legal advisor that spoke about this document being a working document, a document that, of course, can still be changed and added to and deleted, etc. So, Chairperson, I would also like to start off by supporting the Honourable Masango and Honourable Abrams in terms of Section 21. I hope that we can still as a committee find each other here, Chairperson. And I'm saying this because the task before us is to solve a foster care crisis. And if we do not consider Section 21, then the end result is that we will exacerbate the foster care crisis, because we will not allow fathers, unmarried fathers, to have access to care for their children. And that, in fact, will then lead to the opposite of what we are trying to achieve in this bill, which is a court imperative that has been put before us as a committee to try and alleviate this crisis. So that is my first point, and I hope that we as a committee can still find each other here, Chairperson. I also think we need to consider Section 150, the gate, which is the gateway to foster care for orphan children. And I don't think discussions has been held on this by the committee. Secondly, I want to support what the Honourable Masango said. I think we need to ensure that the bill does not contradict itself on the issue of the Children's Court being able to hear guardianship applications. And this is Section 24, 45.1 and 45, 3A and 3B. And then lastly, also, I want to ask the legal advisors, I don't think Section 160, which has been raised by my colleagues, but I don't think we need to insert C, because D already gives the minister a general power or power to regulate anything in the chapter, and this should be sufficient to give the minister the authority to make any amendments. So we just need to look at that as well. And so those are my submissions for now, Chairperson, and then I hope that we can continue to engage each other on these issues. Thank you, Chair.
Thank you very much. The contradiction that you have raised and not insert C, and also clause 121. Thank you very much. That has been noted. I've said Honourable Opperman and Honourable Sukers, and then Honourable Stock.
Good morning, Chairperson and colleagues. Chair, please allow me to switch off my video due to bandwidth.
Thank you. You are welcome to do that.
Chair, I just have two clarity-seeking questions on the new clauses. The new clause 86 to capital A. I just want to know, for my own clarity, will SASSA still have legal authority to pay the foster care grant after November 2022 when the High Court order ends? And then I'd like to know exactly what will happen to poverty-stricken families during that period when the foster care grants expires, because back pay means nothing to a hungry child, Chair. And I'd like to know, or I want to ask for an in-depth discussion regarding Section 151A. I want to know how will it affect or protect orphans that are already in foster care. And I'd like to know regarding the new Section 160, Honorable Liesel already spoke about it, but I want to know for my clarity, that was not tabled in the bill originally, so it was not consulted. So I want to know, why is it now necessary or needed, or why is it inserted if it hasn't been consulted or explained before? And I'd like to know regarding Section 159 to capital A, when the foster care grant lapse now, or no, if Section 159 to capital A won't prevent the foster care grant from lapsing, why does the department see it as part of the legal solution? Thank you, Chairperson.
Thank you very much, Honorable Opperman. It was explained, this what you are asking, some of them, but we will repeatedly, because this is a working document, it needs to be refined, explained, discussed on the. Thank you very much for that question. The next one is Honorable Sukers.
Thank you, Chair. Thank you, Chair, and good morning to all the colleagues. And I also want to just appreciate the comment that was made, or the guidance that was given by the State Law Advisor. Appreciate that we need to deliberate and that this is a working document. I want to refer to clause 24, Chair, and ask that this clause is approved, but subject to Section 45, 1BA being amended by the removal of the words orphaned or abandoned, so that the Children's Court's jurisdiction to hear guardianship applications is not limited to orphaned or abandoned children only, and they can hear all guardianship applications. The section would then read guardianship of a child and contemplated, my apologies, I will repeat that. The section would then read guardianship of a child as contemplated in Section 24. And then this will ensure that the bill does not contradict itself in Section 45(1) versus 45(3)A and 3B. Currently, the bill contradicts itself as it says limited jurisdiction in Sections 45(1) and then full jurisdiction in 45(3)A and 3B. I also want to just support what my previous colleagues have said, especially when it comes to Section 21, which deals with vulnerable children and specifically the rights of unmarried fathers. I think it is very important for us as a committee to consider the inputs that was given, especially during the public submission phase, and for us to not exasperate and put more children in foster care that does not need foster care, but that can receive care from their parents or one of the parents in this case. Thank you, Chair.
Thank you, Honorable Sukers. Now, Honorable Tihan.
Thank you very much, Honorable Chairperson, for the opportunity. Let me also join some of my colleagues who have appreciated the work that has been done or presented to us by the legal person, Advocate Mjengana. I think I also need to appreciate the kind of work that they've put together as a legal team, and then also to put together this particular A list that has been presented to us. And before I move also, Honorable Chairperson, any further, there's an issue which I need to substantively raise in the portfolio committees with regard to a misleading article on the Daily Maverick. When I look at the article on the Daily Maverick, I didn't want to bring newspaper issues to the meeting, Honorable Chairperson. But I think the reason why I've decided to also raise it substantively in the meeting is that I'm of the view that that particular article is misleading society, and it misrepresents the deliberations of the portfolio committee with regards to the clause-by-clause amendment of the Children's Amendment Bill. And I've also noted in the article, that particular article, that is actually running away from the truth and putting there in the public discourse a lot of misleading issues which came as a result of our deliberations in the portfolio committee. Now, in my capacity, I want to state it categorically without any fear of contradiction, and then as a member of this portfolio committee, that I want to officially distance myself from that article because it does not represent the collective or comprehensive deliberations of the portfolio committee. It's just one of our members of the portfolio committee who maybe out of a lack of a proper word, maybe just decided desperately to go to the article and then put her side of the story. And I also want to reject that particular article or the contempt it deserves, because the article, if you look at it very clearly, the article thrives on gutter journalism, in a sense that it's only one side of the story that has been presented. So if it was a balanced reporting of the article, if you receive one side, and then as a journalist who is actually promoting balanced reporting, you know that you are supposed to also consider the other side of the story. So in this case, in the article, I don't see anywhere where the committee secretariat have actually made a comment, whether refuting or agreeing to the issues that have been raised in the article. That's the first thing. And then secondly, I've also not seen any comment from the legal advisor. Now, these are the people that are very critical in the work of the portfolio committee, that are actually advising us from a legal point of view, Advocate Mjengana, also the committee secretariat that have been doing their work throughout our meetings in the portfolio committee. So I'm very disappointed about that article, and I want to raise it in the portfolio committee. But ordinarily, I didn't want to bring stories of the media to the portfolio committee, but I just thought I must raise it substantively in the meeting so that, for an example, I must speak for myself as a member of the portfolio committee, distancing myself from that particular article. Because the article says, when you read the article also, it says ANC members or the ANC contingent. We are being referred to ANC contingent members of the portfolio committee. Now, I want to say here, we are members, like for myself, I am a member of the ANC, representing the ANC in the portfolio committee. I'm not ashamed of that, but I don't agree to be called a contingent member of the ANC in the portfolio committee. But members are free within their right to refer to me as an ANC member representing the ANC in the portfolio committee. I don't have a problem with that, but I don't take it light if you refer to me as a member of the ANC contingent in the portfolio committee. And then what the articles also fell short to raise also, Honorable Chairperson, which I want to raise very clearly in the meeting. The article does not say anything about the members, the members of the opposition combined, who after the meeting corrected, after they lost the debate in the meeting on this inclusion of the Section 21 to be part of the clauses that are surviving. Those members combined, members of the opposition, including those that were not coming to this portfolio committee that are only coming now because there's a particular interest that they are actually carrying or want to put forward. Those members, they stormed out of the meeting. The article doesn't say anything about that. It does also not reflect on the process of the adoption of the surviving clauses in the committee, and then those that have been rejected to form part of the Second Amendment Bill and the Third Amendment Bill, including Section 21. The article does not say anything about that. So I just thought it is important for me to be able to clarify. And then, we are politicians, we serve in this portfolio committee. And then sometimes it's important for us to remind each other about the rules of the National Assembly. The rules allows for the portfolio committee to sit when it corrects and then to take decisions when the meeting corrects. And then the quorum of the meeting is determined by the majority, a 50+1 majority of members of the portfolio committee serving in that particular portfolio committee meeting. So it does not mean that after the meeting is corrected and then there are deliberations in the committee, then we are supposed to take decisions. There are members who feel their issue is not finding expression, then they decide for whatever reason to storm out of the meeting. Then we must now stop our work of the portfolio committee as members because there are certain members who have left the portfolio committee. No, there's work that must be done in the portfolio committee. So whether you feel aggrieved or you feel your issue has been left out, you decide to leave the portfolio committee. You must understand that procedural aspects, which is governed by the rules of the National Assembly in terms of the convening of meetings, the meeting will continue in your absence. If there's a quorum, you have left and there's a quorum, so that particular quorum will then carry through the business of the committee for that particular day. So I just wanted to raise that in a nutshell. I didn't want to respond in the group where the article was also shared, but it's important for us to clarify each other moving forward. And then the bill is now, we are at the A list now. There are stages that we've considered as a portfolio committee. Now, honorable members are coming today and they want to derail again the work of the committee and take us back. Instead of considering the A list where it is now, they are still proposing and supporting each other around taking out this particular clause and then put this one, no, we don't support this one and all of that. So I think the issue that must be clarified clearly in the meeting is that what is our role as members of the portfolio committee when it comes to the A list and then the process moving forward as to what needs to happen. I don't think we're at a stage now where there are members of the portfolio committee who have missed 1 or 2 meetings. Now, the committee took decisions. Now we are presenting today, we are being presented for the A list. Now there are people who still want to drag us back there where we were when they stormed out of the meeting. They still want to drag us there. Now, the issue that I want to also put very clearly in the meeting, honorable members, with regard to Section 21, and I've been raising it very clearly in the meeting, and I was on record saying the issues that are raised by the Fathers for Justice for the inclusion of Section 21, this one of the, which deals with the custodianship of the children. I am, as a person, as an individual, as a father as well, I am married, I'm in a marriage, but also I've got a child out of wedlock, which I'm also taking care of outside the marriage. So issues that have been raised by the Fathers for Justice, they affect me personally. And I'm also sympathetic as a father to those issues that have been raised by Fathers for Justice. But now, because we went to different public hearings throughout the country, there are also, besides the issue of Fathers for Justice, which have been canvassed very properly and very clearly with us as a portfolio committee, there are also a number of stakeholders that have raised this issue. And then, for an example, is the issue when we went to the Eastern Cape, the issue of the cultural aspect of the inclusion of the Section 21 in the bill. Like the issue of paying for, if you've got a child with somebody else, and then in order for you to get access or to get custody of that particular child, you are supposed, in terms of the culture, to pay what is called damages. And so there are a number of cultural connotations that we are supposed to consider. That's why we're on record saying we are not rejecting, and this thing, Comrade Mjanya, Advocate Mjanyana put it very clear in the meeting. And then this thing has been explained to us from time to time, even the legal advisor from the department on this thing of rejection. We are not saying we are rejecting or throwing the issue of Fathers for Justice out. That's not what we're saying as a portfolio committee. What we're saying is that because there needs to be consultation also of the House of Traditional Leaders, considering the issues of different cultures that are also there, and then the issue of custody also by the Department of Justice and all of that, having to look at all these other court judgments that were there with regard to the custody of children and all of that. So it's a number of other public participation process that we need to consider before just accepting or including Section 21. And then the second thing, before I close now, Honorable Chairperson, without taking a lot of your time, we have also agreed that instead of looking at everything in the bill or taking this bill, taking this clause and all of that, taking a lot of them, we are also at the back of our mind. Now, the department went and approached the court already for extension. I think under correction, if I speak under correction, it was already twice where they had to ask the court for an extension on the issue of the foster care. Now, we have agreed as a portfolio committee, let's consider first and foremost only the foster care related clauses. And then once we have done with the foster care related clauses, and then through a committee bill that will be presented to us, then we consider all these other clauses that are there. And I hope honorable members will actually understand us from where we are coming. Thank you very much, Honorable Chairperson. That's my submission. Thanks.
Chairperson. Chair.
Hello.
Please, may I just quickly address you on a point of order. I think, Honorable Stock now refers to an article and he's attacking opposition members, an article which many of us have not read, and we do not understand the implications of what he's saying now. But the fact of the matter is, Chairperson, we came to this meeting today in good faith as a committee. We are a family, and we've all got one goal, and that is to protect the rights of children. And now for Honorable Stock to say that opposition members want to derail the work of this committee, I think it's very unfair. I think, it's a complete onslaught on members of this committee who are supposed to be a family. We don't know what article he's referring to. And, Chairperson, for those of us who decided to walk out of that meeting, it was our right to do so because we had felt that we had consensus on an issue, and we are back here today to debate issues which we think are very important for the rights of children. But, it's very hurtful then to be attacked from a fellow colleague, opposition members this and opposition members that. And I think really it will derail the work that we've got to do here today, which is very important and it's very unfortunate. And then lastly, I want to say again, on the issue of Section 21, Honorable Stock has got his views, but I also want to point to him that Section 21 was rejected by the Fathers for Justice. They do not want Section 21. So it's not that we're bringing an issue for Fathers of Justice. We are bringing an issue which we think will solve the foster care crisis. So I just wanted to put on record my own personal grievance with what Honorable Stock has just said by saying opposition members are this and opposition members are that. We are part of a social development family here, a committee, which must do work in the interest of vulnerable children. And I don't think what he said now was fair to all of us, Chairperson. Thank you.
Noted. Can I proceed with the discussions from the honorable members? I think how many honorable members are left now? Let's first give the ones that haven't managed to speak, because Honorable Stock was addressing the article that was on paper, which I didn't want to open up the remarks in terms of talking about the papers and the media and all the stuff. But nevertheless, let's, as a family, I also regarded ourselves as a family, really. We have to behave and do things as such. So there is a hand of Honorable Briet that I haven't given. I could see also there are also hands that would like. Remember, we still have to answer these questions and concerns that have been asked. But I will also get into before the legal advisors come up. I have to give a direction of the meeting. What is it that needs to happen? Honorable Briet.
Thank you, Madam Chair. Madam Chair, yes, I would like to firstly start off by agreeing with Honourable Liesel van Merwe. I really take exception to what was insinuated about me from the Honourable Stock, that I am only here for political gain, that I am only attend meetings when it is for political gain or to prove a point by the opposition. I was not part of the public hearings because I'm not an official member of this committee, but I do attend most meetings when it does not clash with my primary portfolio committee, because at the end of the day, I would like to, as this committee, as this social development family of this committee, I would like to be there for the children of South Africa because it is as important to me as it is to the other members. And I really feel that the Honourable Stock is the one that has derailed this meeting, that is taking us back. And with all due respect, ma'am, not the members of us that stand together or that walked out of that meeting. But Madam Chair, maybe let me start and get to my point. And I would like to also utter, as my colleagues have done, my appreciation for what the state law advisor said in terms of acknowledging the fact that this is a working document, much needs to be done, and after this foster care process to actually include the other sections, because I think we need to holistically look at this act, even though that is not necessarily requested of us. I would like to second Honourable Masango and Honourable Abrahams when they refer to Section 21. I think the rights of unmarried fathers, taking into account, Madam Chair, the immense pressure that our foster care system is under, the tremendous issues, the lack of social workers we are experiencing, that really needs to be taken into account, Madam Chair. I think, and then because I do not believe there was a seconder, Honourable Mari Sukkers proposed that there be an amendment to Section 24 with and I missed it, or I haven't written it down, the abandoned and orphaned children, to actually ensure that it does not contradict Section 45A and B. I think that is a good proposal, and I would like to second that on record, Madam Chair, and I think I would just leave it at that. Thank you.
Thank you, Honourable Member. Let me also give the direction for the meeting. Honourable members, let me remind you that I see the hands of Honourable Alex and Liesel and Bridget and Sukkers. I don't know whether it's the hands that they were raised before, but if it is the case, they must lower their hands. But let me give a direction on this meeting. Honourable members, on such a day that I can't remember the date, the meeting set after we have agreed to restart the process. And we agreed that Section 21 is fine. There are clauses that are put in abeyance. We'll come back with Section 21 because we have to do a thorough consultation. We even suggested that it needs to be taken to House of Representatives, because we're not going to do what we did in terms of going around to provinces, but it has sort of a cultural thing. Then we agreed on that particular meeting that let's put Section 21 or Clause 21 in abeyance. That was the resolution or the recommendation and also the agreement in that meeting. So can we, much as we have noted, because we discussed it at length, what is it that is there? Is it also deals with foster care? Is it also deals with, but also even if it deals with whatever, it also needs a thorough consultation out of the public hearings that we had. It doesn't mean that we have thrown Section or Clause 21 into a dustbin. So can we allow the meeting to proceed in answering the legal advisors as opposed to answer in the state law advisor on something that you have raised a concern on it, as I have noted them down, as we will go back to the second phase of taking hands again. There was a question that was asked by Honorable Masango from the very first hand we got. I requested him, it is in terms of section 2024. All those I said, let's put them aside and note them. They will be answered. Can I give the legal advisor, his parliamentary advisor on this concern that have been raised? There's lots and lots of questions, but we will remind one another if there is anything left. Then we will give over the second tranche of follow-ups or second round. Can we give over to the legal advisor? Otherwise, we really have to treat one another as a family. And if we can see that we can correct one another, it's fine. But let's not really fight amongst ourselves. We really appreciate that. But honorable members, when you decide to leave, it's your right, you are right. But it was really, I will say, unprofessional, because one person, when he leaves or she leaves the meeting, she informs the meeting that I have to be excused on this. Anyway, it's a past. Let's not get into that. It's not there or not there. Let's continue with the meeting. Now, I appreciate the presence, 100% present of this, so that we can, at the end of the day, not request the extension for the third time as people that really are not interested in this children's amendment bill. Can we then give over to Mr. Mchengani? Are you there, Mr. Mchengani?
Chair, can I first attempt to answer some of the questions?
Oh, okay. Do you want to start?
Yes, Chair. It's Lisa Naidu from the Office of
Lisa. Okay, let's give you, and then so that we can move on this, because even this one of section 21 has been answered time and again, but it doesn't mean that we can't repeat what we have said on this according to the advisor that we got from the legal advisors. Thanks. Over to you, Liz. Before you, Mr. Mchengani.
Honorable members, I would like to apologize in advance. I hope you can hear me. If you hear dogs barking, I cannot control my environment, so I do apologize for that. I'm going to start with clause 24, which is section 45, the amendment to section 45 in the bill as introduced. I'll start with the first one by the insertion in subsection 1 after paragraph B of the following paragraph. Members have indicated an alternative wording for guardianship of an orphaned or abandoned child as contemplated in section 24. Interestingly enough, Advocate Mshoshiza had educated me in the correct terminology. Rather than saying orphaned or abandoned, he proposed that we now use the term a child in need of care. So I have considered what the members have indicated, and I am in agreement that that would not be a drastic change to this, and it would be acceptable in terms of drafting standards, if the committee agrees to the change of that wording. The other question that was raised related to section 24 and the cross-referencing. The reason we didn't change section 24 to refer to section 45 is because in the amendment to section 44, if you see line 15, the new 3A, we had made reference and said the High Court and the Children's Court have concurrent jurisdiction over the guardianship of a child as contemplated in section 24 of this Act. So because we put in as contemplated in section 24 of this Act, it would mean when you read section 24, it's applicable to not only the High Court, but the Children's Court. So that's our explanation of why it was drafted in that manner. However, once again, this is a working document. The decision ultimately lies with the committee. Should you decide that we must go and amend Section 24 to provide greater clarity or ease of reference in the bill, that is not a drafting impediment, and there's no obstacle for us to do that. I hope I've answered the questions relating to Clause 24. I'm just going to move on. Sorry, Chair, I'm referring to different papers and documents. The new amendment to Section 160. Section 160 deals with the making of regulations. And one of the members raised the issue that Section D is an all-encompassing provision. And I agree. The department can use that to make regulations. But just some insight in terms of our office, whenever departments make regulations and refer to an all-encompassing clause, regulations must come from an enabling provision. And it's better if it's explicitly stated. But once again, this is the decision of the committee. And Section 160, we had considered the public comments in terms of the amendment to Section 155. That's Clause 83. And the public comments were very strongly recommending that there be a quality assurance process. And that procedure, they wanted us to insert in terms of Section 155 or under Section 155, Clause 83. But in terms of drafting practices, NATI, the Parliamentary Law Advisor, and all our legal advisors, we're guided by Thornton, legislative drafting, and a legislative drafting manual, which more or less says, like provisions must be under the specific headings. So anything dealing with regulations is best placed under the clause dealing with regulations. So instead of inserting it under Section 155, we therefore decided in terms of drafting practices to create a new 160, I think it's C capital A. So that was our reasoning for that issue. And then I'm going to move on to, I think it's Clause 10, Section 21. As it stands in the bill as introduced, if the committee wants to agree on it being in the bill as introduced after it's been through the constitutional process and vetted by our office, it would be acceptable. However, I have went through the comments received by the public. It's valid. It must be considered further. But it's of such a substantial nature that other legislation requires that whatever we draft needs to go through other processes. It needs to go again. When it becomes, if it's a part of the committee bill, it's going to be vetted very carefully. It's going to go through public comment again. It's going to go through the House of Traditional Leaders. And that's procedurally, constitutionally sound. If us here, if the Parliamentary Law Advisor and myself redraft that clause and insert substantial amendments, which hasn't gone through that process, the constitutionality of the entire clause will be compromised. And I've seen the comments. It's so valid. It's not only going to be Section 21. Sorry, Chair, it's very cold here. I've looked at it, and what the comments are looking at is not only Section 21, it's actually Chapter 3, parental responsibilities. And I think when we go through the committee bill, we're going to have that power to go further than Section 21 and look at Section 18, 19, and 20, and 21. Thank you, Chair. We are actually freezing here in Pretoria.
All over. Lisa, we are also freezing here in Eastern Cape. Sorry for that. Thank you very much for that explanation. you know, you are repeating about this section 21 thing as you did before. And I am happy that you kept on repeating it. We will repeat it until the honorable members understand it. On why do we say that? For now, let's not include it until we wait for this thing of consultation, thorough consultation, so as not to compromise, because I like the terminology that you are saying, let's not compromise it. It's not that we're not going to deal it, and we even requested the advisors whether to tell us what is going to be the plan going forward in terms of after this consultation that they're going to do, because there's lots and lots of clauses that we have to tend to. Thank you very much. You have also answered about section 24, this thing of the guardianship and abandoned child, the one that was being asked by Honorable Masango. Then can we also give, and also you go to 160. I'm happy to hear that. I'm ticking in my notebook. I might left other things, not intentionally, but by mistake as a person. Can we give over to Advocate Mchemane?
No, thank you very much, Chairperson. Chairperson, I must state that my colleague Lisa Naidoo has finished everything on my plate that I thought I would be contributing in respect of the responses to the questions of the members on section 21, 24, as well as 160 of the proposed amendments. I have nothing to add, Chairperson, in respect of my of the contribution that my colleague has already given. The only thing that I would raise, Chair, is the questions by Honorable Alex in respect of why the deletion of the provision.
Yes, of definitions.
Chairperson,
yes, and also the definition.
Yes, Chair. So, Chair, in the response really to that question is that the deletions are as a consequence of the committee's decision to only focus on foster care parenting. So to only survive those clauses in the bill that directly refer or relate to foster care parenting. So in our drafting, we felt that those clauses which have now been listed there are clauses which fall to be kept in abeyance and not necessarily form part of this amendment process because they're not directly linked to foster care parenting. So that is just the consequence of all of other clauses that have been rejected. And in the surviving clauses in the definition are those clauses which were directed by members to include as clauses that fall within the foster care parenting. Those would be reflected properly and clearer in the B version. So that is just my input, Chair. The other thing that I just wanted to state, also the questions about SASSA are just operational questions that I think, Chair, the department is best placed to respond to. Also, the questions by Honorable Aris are probably going to be best placed. The issue of the shortage of social workers are probably going to be best dealt with by the line function department, which is the DSD. The issue of
also that one of the lapsing.
Yes, Chair.
After November, whether it's from my Honorable Opperman, I'm sure the department is ready to also, because they explained that, but they need to repeat it, what's going to happen.
Absolutely, Chair. And then, Chair, the other issue I just wanted to say as a last comment on my side is that in this process of, as my colleague Lisa Naidoo has already mentioned, in this process of considering the A-list, Chairperson, we as the technical legal support to the team are ready to give effect to the decisions and instructions of the committee on what it is coming from deliberations that we need to amend. We would then go back again if there is a need, Chairperson, to give technical, practical implementation of such decisions. So Chairperson, our role really in respect of how the committee decides based on the advice we've given to which way the committee decides to go in respect of those clauses 21, 24, etc. We would then be in the meeting, Chairperson, to take instructions from the committee and decisions on how to best implement its decision in respect of that from a legislative perspective. Thank you.
The limited jurisdiction and contradiction by Honorable Sukers.
Chair, that is a matter that has been answered by my colleague Lisa Naidu, because it's relating to the amendment of section 24. The whole
yes, 24.
Yes, so that's the amendment to section 24.
Section.
Yes, Chair. So it's the same with the Honorable Briet's input in respect of the same section. Chair.
Okay, thank you very much. Advocate Mthoshisa, are you there? Repeat yourself in terms of the lapsing period, because I think you have answered that, because really as a committee and members, we were concerned about what's going to happen after this.
Thank you, Honorable Chair, and good morning, honorable members. Yes, indeed, with regard to the issue of the lapsing, we rely on the court order and also the finalization of this bill. The challenge that we are going to face is that if the bill is not finalized by the end of this year, that is by the end of November, it will pose a challenge to the court orders, to the foster care grants that are being paid in terms of the court order. The court order comes to an end at the end of November. So the sooner this bill gets to be finalized, the better for the foster care grants that must be paid. So we rely on this honorable committee to finalize the bill with regard to that. Thank you. Let alone that there is that 6 months period that we have indicated in the bill itself, that those that will have lapsed will be entertained for a period of not more than 6 months. But beyond that, there will be a challenge in terms of implementing the foster care grants. That's basically the response. Otherwise, the rest, my colleagues have already responded to that. Thanks, Honorable Chair and honorable members.
I think you have answered it the way you answered it before, in terms of telling us the period, and also you said you will guard against that, because it mustn't happen at least. But I see the hands? It's the second phase, ne? Okay. The first hand is Honorable Alex, and then followed by Honorable Bridget, and Honorable Lisel, and then Honorable Mangai. Can we go on that? Over to you, Honorable Alex.
Thank you, Chairperson. I thought that I was going to do the surviving clauses at a different stage, but seeing as everybody is speaking to it now, let me also then use the opportunity and rather speak about it sooner rather than later. So I've got two additional questions, and that's got to do with clause 86, and that's in section 159. So the new proposed clauses in A, wait, let me just see, yeah, in 2A and 2B. Why is it that in 2B, they make mention of the exact date of this Amendment Act in the reference of 2B, but they don't give any reference to it in 2A, as in stating at which time after the Act is implemented and so forth. So why is it only inserted in 2B, where it states before on the date of this Act, but they make no reference to it in 2A in terms of a time frame principle? Then, Chairperson, it is clause 82 in section 150. And if I go to the Principal Act quickly, and of course it's 150, and it goes, one, a child in need of care and protection, if such a child, and then they want to insert this new clauses in terms of I is an unaccompanied migrant child from another country, and K is a victim of trafficking, and then L has been sold by a parent or caregiver or guardian. So my question is more around K in terms of a victim of trafficking that would then need to be placed, is then classifies the child in need of care and protection according to this. What would it be if the child is then kidnapped and there is still a parent and it wasn't negligence on the parent's side? Would this clause then saying even a child that still has a surviving parent or guardian that was then kidnapped for purposes of victim trafficking, would they still be in need of care and protection? Because that's my understanding. And then the child doesn't go back to the parent, once that child is found. Then, Chairperson, I've heard the Advocate Naidu on Section 21, but then my question becomes to the advocates, practically and realistically, and I've heard that it needs more consultation and second bill and all of that, but practically and realistically, then what are our timeframes that we are looking at to then do this? Will it still be within the 6th term of Parliament? Keeping in mind that we're going to be heading into an election year, in 2024 and all of that. So you'll be talking about putting it off, but realistically, will it still then be this committee that will be, as in the composition of this committee, doing that, looking at times? And then, Chairperson, just because you allowed the Honourable Stock to bring in this topic of the article, I just want to let you know and the other members know that I also take personal concern to the insinuations made. And also, Chairperson, we know as members of Parliament that if we disagree with a journalist, we don't bring it here to a committee meeting. We then write a rebuttal to that journalist. So, Chairperson, I'd just like to know that I'm also deeply concerned that the topic was even allowed to be discussed and the aspersions and the insinuations made by the Honourable Stock and other members. Thank you, Chairperson.
Okay. Maybe I need to quickly answer this one. Remember, I said the advisors are going to give us the plan on how far are they going to take. In the last meeting or previous meeting, we requested at least 3 months for this consultation because it can't be going on and on and on. I assume that it needs to be. In fact, we have to enforce that it needs to be during our term. So we cannot abandon this. We cannot put them aside. That one I would like to just respond on it. But let me allow honourable members to put their Lizelle. It's Honourable Lizelle and then Honourable Jane.
Chair, you skipped Honourable Masango. She's before me.
It's Manganye.
It's Manganye who was there. And then now
okay.
I see the hand off. I am looking at my card, sweetheart.
Thank you.
So
Thank
give
you,
me
Chair.
a chance to chair. Thank you very much.
Thank you
then
very much.
I'm giving over to Honourable Lizelle.
Thank you so much, Chairperson. Mine is just again a question of clarity. Now, orphans in the care of family members are not in need of care and protection, but Section 151A, the amendment now says that. So I want to ask, are we then saying that all grannies with orphans must go to the High Court to get guardianship? And if that is the case, to which court will these grannies have to go for guardianship? Because if we go with the suggested wording of Section 45(1), then they will have to go to the High Court. And of course, that scenario will be highly problematic. So I just wanted to get clarity in that regard. Thank you.
Okay. Thank you, Honourable Lizelle. Honourable Jane. And then you'll follow by Honourable Masango.
Thank you, Chair. I think Liz Naidu have covered my question, because I wanted to say something about section 1, of which I still can put to what I was going to say. I was going to say exactly what she said, because I think even in the previous meeting, I also alluded to that we have to take also other people's culture and check and balance, because we are this broad church as this government. So I think she covered me very well on that issue, Chairperson. Thank you.
Thanks, Honorable Chair. And then Honorable Bridget. Honorable Bridget.
Thank you, Chair. I am so sorry. I was kicked out by the system earlier. I just wanted to, in line with what that Ms. Naidu explained and responded to the questions that some of which I had asked, just to say that when the chairperson is really adamant that these questions have been answered, and I agree, but maybe we need to be sort of pardoned for not understanding the explanations that are given. I'm saying this, Chair, because it was said earlier on that the issue of the section 21 and the need for proper consultation, and especially with the House of Traditional Leaders, and the need to take care of culture. If one could just say that maybe the problem why, or the reason why we still wanted it to be included, is because of the extensive consultation that happened during the public hearings and DSD, the Department of Social Development's own agreement to the inclusion of Section 21, but also the Principal Act, Section 21, if I can just say Section 21B, says, Section 21(1)B says that, and I quote, if he, regardless of whether he has lived or is living with the mother, Roman figure 1, consents to be identified or successfully applies in terms of Section 26 or to be identified as the child's father, or pays damages in terms of customary law, which I believe very strongly, Chairperson, that it does take, there has been before extensive consultation, and that the Principal Act itself recognizes that extensive consultation in terms of culture and things like that, that in the Principal Act, this aspect is being taken care of. I just wanted to put that on the table, Chair, and as I appreciate you saying that we have been explained this over and over again. And the other issue, Chairperson, that I would like to really, even as the advocate Chochisa had said that it's going to be taken care of, the issue of the lapsing of orders is going to be taken care of by the 6 months extension and by the passing of this as an act after the November 2022. I just want to say, Chairperson, that here we, at least in my view, and the views of many other people that I've heard speak about this, is that we have a situation where, yes, the extension is granted, but there is a issue of the backlog not being alleviated, because after the passing of this bill into act and this section, it doesn't enable the expired foster care orders to be paid. There still will be no payment. Yes, there will be a longer time, but children still are not getting the foster to know at whatever stage. I'm not saying that it has to be done now, but I'm saying at whatever stage the drafters need to be able to accommodate that aspect, because that is what brought us where we are now, the backlog, which at the moment I believe is sitting at over 300,000 foster care grants. I am not, Chairperson, going to venture into what the Honorable Stock has said this today, because I believe that his assertion that the article is derailing, or the members are derailing, it's general.
You are breaking, Honorable Masango.
To start off with, so I don't know.
Mamela, Honorable Masango, you are breaking.
The Honorable. Okay.
Honorable Masango, you are breaking, you know. It's just that I'm not sure whether you are breaking to me only or even other members were unable. But for the first part and also other things, we managed to hear you. And we have taken note of what you are saying. But yeah, let me check whether are there any other hands. Marie?
Yes, Madam Chair.
Alex, excuse me before Marie. Alex, is your hand up or is it an old hand?
It's up, Chair.
Okay. Marie? Thank you.
Yeah, Chair. Thank you, Madam Chair. Yes, I think I will follow suit, which is wisdom from Honorable Masango, to not venture into replying to the assertions made by Honorable Stock. Safe to say that I think this morning I certainly came with the idea that we need to move forward and we need to work at speed, but also with efficiency around the issues as it pertains to vulnerable children. And I think most of the committee, or all of the committee, I think, has the same aim. And so it is not going to be helpful to venture into that. So I'm not going to answer that. Safe to say the one thing, which is what the State Law Advisor has said in the beginning, that this is a working document, that it is the committee that needs to deliberate, and it is within that context that we need to look at it. And for that reason, I'm going to go back to say the importance of Section 21 and 24 and why it was important, Chair. It was important because we are looking at children that are within the foster care system and looking at how do you make it easier for relatives or for guardians to take care of orphans if they need to go to a children's court in terms of jurisdiction, and then also in terms of the capacity of parents to look after their children, so that we lessen the burden on the foster care system. The matters of deliberation is around those. How does it impact the vulnerable child that is in need of care? And it is our job, to apply our minds to that. And it is my understanding from what the State Law Advisor has said in response to my my points on Section 24, and that of seconded by my colleague, Mrs. Breed, that there is no issue for that to be included as part of the amendments. That is my understanding, unless I have misunderstood what she has said, if she can possibly clarify. Thank you.
Okay, Alex.
Thank you, Chairperson.
Thank you.
Thank you for allowing me this another opportunity. So I just want to go back to Section 159, Clause 86. because I'm still unclear. So maybe let me paint a scenario for the department and they can then answer, to a specific scenario. So if a child's foster care order expires on 1 March 2023, and the social worker relies on now this new section 159(2)(a). So, and it doesn't take the case to court to get the order extended because she knows she can go at a later stage because of this new clause. But the Social Assistance Act says that SASSA can only pay the foster care grant if the court order is valid. So SASSA stops the grant on that 1st March 2023. So my question to DSD is now, why do you think that this clause 2A will prevent the foster care grant from being stopped? And the concern goes further, Chairperson, is because SASSA is being audited all the time. And the only reason why they aren't being negatively audited is because the High Court is protecting SASSA from getting a bad audit. But once this finishes now in November 2022, the court order expires, SASSA will have to stop the grants that has expired. So I think that's the question that I think Honorable Opperman and Masango and many others are trying to get at. What happens then? And so maybe the department can use this practical scenario and explain to us what happens in November when it expires and how this new section of 159(2)(a) is going to aid in this scenario. Thank you, Chairperson.
Thank you very much, honorable members. Can I again give the department Advocate Mtshutshisa to answer exactly what has been asked in terms of the expiring or lapsing of? Can I give over to the department?
Thank you, Honorable Chair and Honorable members. What this provision is actually saying is that there will be a 6 months extension when ordered.
Come closer to the mic. Come closer to the mic, Advocate. Okay.
The issue around this provision, Honorable Chair, is that the court will automatically extend the orders that will have lapsed at that stage for a period of not longer than 6 months. So this is what is going to happen. And these provisions must be read together with what the Social Assistance Amendment Act is also saying. So there is actually no conflict in terms of these two pieces of legislation, but they must be read together, with this provision being the provision that details how this matter has to be handled. So the understanding is that the court orders will have ordinarily lapsed by the end of the financial, that is by the end of November, when the court order expires, and then what will happen to those orders in the cases that have not been dealt with. So the court will give a period of 6 months extension so that there can be continuation of the payment of those. And this must be read together with the legislation that is already in existence. And this is in line with Section 48 of the Children's Act. So it's not important, I mean, to construe this from the context of this particular provision in isolation from the rest of other provisions that deal with the same matter. So this provision must be read together with Section 48, which grants the presiding officers a period, I mean, powers to extend this for a period of 6 months, and also what the Social Assistance Amendment Act is saying. So they must be read together. Thanks, Honorable Chair.
Thank you, the Advocate Mtshutshisa from the department. And can we get to Alex Alex's question and Lizelle's question. Advocate Mjengana.
Chair, Advocate Mjengana, the system kicked him out.
Joe. Oh, where's Lizelle? I mean, Lisa.
Lisa. I think Lisa's still here.
Lisa?
Yes, Chair, I am present.
Yes.
With regard to
82,
the question,
clause 82.
clause 82, victim of trafficking.
Mm-hmm.
I don't fully
And
understand.
kidnapping.
I don't fully understand the question, but maybe I can give some clarity if I read the section 150. So section 150 in the Act currently says,
okay.
Just getting to that page in the Act. Child in need of care and protection. 151, subsection 1. A child is in need of care and protection if such a child, and then we've got a list, and then we add if such a child is a victim of trafficking. So I'm not sure if that answers the question, but if you read it together with the Act, we are listing children or we are listing in what instances a child will be considered a child in need of care and protection. And that would be, is an unaccompanied migrant child from another country, is a victim of trafficking, or has been sold by a parent, caregiver, or guardian. Those are the 3 additions to the current list. Chair, for the other question regarding the other clauses and the committee bill, the rules of parliament has, and this is where my colleague, the parliamentary law advisor, can explain better, but how committee bills are to be dealt with. And practically and realistically, our office of the Chief State Law Advisor cannot answer that question because we cannot direct the committee in terms of timeframes. That is squarely on the committee in terms of your rules and how you'll apply it. In terms of Section 21 already going through extensive public comments, I agree. It has gone through such extensive public comments, and this is an area of contention. And that is why it needs precise redrafting because, and correct me if I'm wrong, the committee is not taking Section 21 as introduced. It's relating it to the public comments. It needs extensive redrafting. And as I've indicated earlier, when it is so extensive, it needs to go in terms of the committee bill. Once it's drafted, back for public consultation, because there might be a group that will want to comment on the precise wording as we've drafted it. So that's our drafting processes. Chair, I hope I've answered your questions. Unfortunately, I did have an issue with hearing and they were breaking up. So that's my to those questions thus far.
Chair?
Chair, I think you're muted.
Okay, thank you.
Chair?
Thank you, Liz. Okay, can I see and look at the hands right now? I think we have exhausted. Who is saying Chair? I don't see any hand here.
Chair, it was just my question that wasn't answered.
Which one?
About the guardianship issue, grannies and courts.
Can you repeat yourself so as Lisa to hear you? Because she was saying that she broke away and then she couldn't hear other questions.
Yeah, I was saying orphans in care of family members are not in need of care and protection, but Section 51(1)(a) amendment now says that these grannies and orphans must go to a court to get guardianship. So I was asking which court should these grannies go to? Because if we go with the suggested wording of Section 45(1), then they'll have to go to a high court. So I wanted to get clarity in that regard.
Thank you. I've written it down. I don't know how have I missed. Lizelle, did you manage to get it? Lisa.
Yes, Chair, it's regarding clause 45, right? I stand to be corrected. It's the relationship between section
151A.
45 and 24. So section 45, because in the amendment to section 45, we've said that the High Court and Children's Court have concurrent jurisdiction over the guardianship of a child as contemplated in section 24 of this Act. Colleagues, I'm not sure whether I'm audible and if you can hear me.
Hello?
Lisa?
Yes, can you hear me?
We didn't hear you clearly. We only had that section 45 and also we only had that.
Clause 24, the amendment of section 45. The insertion of new 3A says that the High Court and Children's Court have concurrent jurisdiction over the guardianship of a child as contemplated in section 24 of this Act. And it would cover anyone because section 24 goes on to say, I'm just going through my Act. Any person, which will include a granny, a friend, a neighbor, having an interest in the care, well-being, and development of a child may apply to the High Court for an order granting guardianship of the child to the applicant. And like I've explained earlier, we said as contemplated in section 24, the High Court and Children's Court have concurrent jurisdiction. And as I've mentioned earlier, by that as contemplated, it will include now reference to the Children's Court. If that is still an issue, then we can, as the committee decides, make reference specifically in section 24 to the amendment, or rather the new section 45. So that will more or less link the two provisions and not cause any confusion.
Chair.
Hello, who's there?
Yeah, Chairperson.
No.
Yeah, I just want to make a proposal. So I think the proposal is that we should make section 24, 45.1 and 45.3a and 3b should all say the same thing. In other words, that guardianship cases can be heard by children's courts and the High Court. So that would be my proposal. As per section 23 above.
Honorable Sukers.
I want to second, Chair, what was proposed by Honorable Van der Merwe. It concurs with what we asked clarity on from Liesel, from the State Law Advisor, my apologies, and that the clause be approved. And I second what was said by Honorable Van der Merwe. Thank you.
Honorable, I think there are no other hands. Is Mr. Mchengane not yet in?
He's in, Chair. He used his phone. He connected with his phone.
Okay. Can we give, in fact, Mr. Mchengane, Advocate Mchengane, did you manage to hear? Did you manage to hear?
No, Chairperson, I just joined. I managed to get the last part of Lisa Knightley's contribution in respect of the amendment to section 24. So I got the comment by Honorable Van der Merwe and Honorable Figures on how they want the jurisdiction to be extended.
And then what are you saying on that?
No, Chair, that is definitely something that's possible from a drafting perspective, Chair. If the committee is agreeable that the jurisdiction be extended, it does appear that it would be beneficial for the extension of the jurisdiction and much cheaper for people who are going to use those, as the processes in the High Court are much more expensive and onerous. So to effect it would be just an easy technical drafting, so it's possible.
Okay, it's a drafting thing, okay. Then if it is the case, honorable members, we have to go to the adoption of this A-list. Can I get out of the deliberations and discussion that we had, can I get a hand that adopts this A-bill, A-list?
Chairperson?
Who's that?
It's Honorable Sukas, Chair. I just wanted to, I think that the State Law Advisor didn't hear my question, perhaps. I just want to know whether she said that when I requested that the clause 24 be approved, but subject to section 45(1)(ba) being amended so that the words orphaned or abandoned be removed, so that it is not limited only to orphaned or abandoned children, but that the Children's Court can hear all guardianship applications. I don't know if she heard that, but I was asking whether she said, and I think if they could advise that if I seconded what Honorable Van der Merwe said, if that still needs to be amended as well, so that the Children's Court be able to hear all cases and not only those of children orphaned or abandoned.
Mr. Chairman?
Chair, I think the member was directing that question to my response earlier. Lisa Naidu.
Okay, Lisa.
Chair, can I read out what I understand is the proposal by the committee so all the members can consider this? So in terms of the amendment of section 45, clause 24, section 45 of the Principal Act is hereby amended by the insertion in subsection 1 after paragraph B of the following paragraph. So BA is the one that's the wording needs to be changed. Will it be acceptable if for BA we just place it as guardianship as contemplated in section 24? Then it will cover the list as written down in section 24. And I'll read section 24 for you, Leah. Any person having an interest in the care, well-being, and development of a child may apply to the High Court for an order granting guardianship of the child to the applicant. So if it says guardianship as contemplated in section 21, then as I've read section 24. So it will be linked to section 24. And then the members are, and correct me if I'm wrong, because I do have a hearing problem on this side with the connectivity. Then we would have to amend section 24 to say any person having an interest in the care, well-being, and development of a child may apply to the Children's Court as contemplated in section 45(3)(a) for an order granting guardianship of the child to the applicant. That's what I've gathered from what I've heard so far, and I hope I'm corrected on that. But if that is what the committee decides, the Parliamentary Law Advisor and I can amend it accordingly.
Parliamentary Advisor, your input on this? Mr. Mjangman? Hello? Lindy?
I think the system kicked him out and they
Yo.
phoned him.
It means that he didn't hear what Lisa is saying.
Okay, can Ms. Naidu please repeat it again?
Okay.
Before we go there, may I just make a suggestion? Her suggestion for the changes to 45(1) is accepted, but in section 24, she left out High Court when reading it. It should say Children's Court or High Court. So we should be using the same wording as section 23, but otherwise she was on the right track.
Can't we wait for her to repeat what she was saying? Lisa?
Yes.
Are you
Chair.
able to hear?
Yes, Chair.
Honorable Alex is asking you to repeat yourself or try to or come closer to the mic. I don't know whether she broke and she couldn't.
Colleagues, when we draft in
Come closer.
Chair, can you hear me?
Yes, it's better now.
Yes, Chair. I was just saying this is a very quick drafting session. So apologies if I omit anything. Do I need to repeat 24A with respect to guardianship as contemplated in section 24? Or is it only?
Yes.
Okay, I need to repeat everything. Amendment of section 45 of Act 38 of 2005. This is clause 24. Section 45 of the Principal Act is hereby amended by the insertion in subsection 1 after paragraph B of the following paragraph. B, capital A, guardianship of an orphaned or abandoned child as contemplated in section 24. We will remove the words of an orphaned or abandoned child, and it will read guardianship as contemplated in section 24. So I'm going to read section 24 now. Section 24 says, assignment of guardianship by order of court. 24.1. Any person having an interest in the care, well-being, and development of a child may apply to the High Court for an order granting guardianship of the child to the applicant. So we will delete to the High Court, and we will insert to the Children's Court or High Court as contemplated in section 45(3)(a). Thank you, Chair.
Thank you, Lisa. Where is the parliamentary advice? Not yet.
He's just joined now, Chair. He's just in. Jangane?
I think he's waiting for you to let him in.
No, he's in.
Okay.
Kaya, he's in. I let it in. I just.
So we seem not to manage to get
He's coming in now again, Chair. The system kept on kick him out. He's trying to join again, Chair. He's in, Chair. Can you check him?
Yes, Chair, my apologies. I'm back in. I'm having some very serious difficulties today. I'm sorry.
Chairperson, Mr. Mjengane is in. Chair, can you hear me?
Yes, I hear you, Lindy. This is really tiring. Yes, we have to be patient and also give ourselves time, especially we know this challenge of kicking out by the network, which we cannot do anything about it. Mr. Mjengane?
Hi, Chairperson. I'm in. My apologies. I'm having some technical challenges today.
What can you please assist us in this section? I think Liz has tried to explain it as much as she can.
Chairperson, is that in relation of the amendment section 24?
Yes.
Chairperson, my input was in support of what my colleague Lisa has said, was that if the decision of the court that the tuition must be extended to children's courts, the decision of the High Court, and therefore we must amend accordingly, it will be possible for us to do so. So, on our perspective, it's really a matter of us taking the instruction from members of how they require for us to amend the section that we want to give effect to that decision. So I don't know, because I used as a part of the discussion here, I don't know if this covers your question.
Mr. Mjengane, honorable members wanted you to repeat what you have been saying, and they would like to make sure that they understood you. And then Liz tried also to explain on what is it and put it forward to the honorable members to discuss.
So Chairperson, my input was that the contribution of Honorable Sugas and that of Honorable Fanabak, which is the part that I had in respect of section 24. So, yes, so my input was that, Chairperson, from a drafting perspective, we would then go away and amend the A list in respect of the members' input in that clause, give effect to the committee's chair. And we would, if the committee adopts the A list, for instance, today, with those amendments in that clause, we would then go back and amend it in line with the members' input. And then in the next meeting of the committee, we'll present the draft A list reflecting the members' input together with the B version incorporating that input. So that is what I was saying.
Okay. Okay, Mr. Mjengane, I think that was all that the honorables wanted us to look at. And out of that, you are also, Lindy, can you give us the direction now? I think we are done with the deliberation and discussions and discussion. Yes.
Sorry, Chair.
Who's that? Masango, Honorable Masango.
Yes, Chair. I've been also just been kicked out in and out, so I don't need the restating of what has been discussed, but I just need to know if the process now that is leading us to the considering of the A list has taken care of each and every clauses and related sections that we have raised today, so that we know that it is the committee is, for example, when I say section 151A, where I am proposing that we use the wording that says orphaned or abandoned and not in the care of a family member. I need to know before we go to the approving or not approving of the A list to say, okay, we've heard that, but we don't think it's going to be possible. And then we go to section 160, for example, and we say, yes, we heard that, but we don't think it's going to be acceptable, or it's going to be changed, or the committee can consider that, because I think that we might have things fall between the cracks if we don't do it in a way that is listing everything that our legal advisors have heard us say today and their response to that, so that we base our approval of the A list on the basis of their responses to our proposals, as it were. Thank you, Chair.
Mr. Mshangman?
No, thank you, Chairperson. Chairperson, in terms of process, the input by members. So the A list now is our attempt of giving effect to the discussions of the committee and instructions to us to go and give effect to the proposed amendments by the committee. So this is what we've tabled before the committee, and the committee has been considering today. So there has been a number of discussions by committee members on respect of specific clauses 21, 24, and the amendment, which is at section 160 of the Act. So Chair, for us now, in order to go further in the amendment process, is for us to be given a decision by the committee on the basis of these issues of contention that the committee has been discussing. So, for instance, if the issue of clause 21, I don't know, Chairperson, please forgive me if the committee has decided the matter already. If, for instance, the issue of clause 21 is that clause 21 must not form part or must form part of these amendments, that's the decision the committee needs to take, and we will give effect to it from a draft perspective. The same with 24, Chair, as well as the issue of the amendment 155, which we effected by proposing an amendment to section 160 of the Act. So the decisions, Chairperson, will be on each of the clauses that we've put before the committee, giving us directions as drafters as to what to include and what not to include. So, for instance, in respect of 24, members have already proposed that we must amend it such that it extends the jurisdiction. So that's the instruction for us drafters to effect. So we take that instruction. So, but in respect of other clauses, we would need a decision from the committee in respect of how to effect its decisions in respect of the rest of the clauses that are being discussed. Thank you, Chair.
Honorable members, that's it. But Mr. Mchangane, or Advocate Mchangane, we have dealt with section 21 and we are done with that one. We said that we are not throwing it to the dustbin, but we still need more consultation. We even made mention that we have to deal with it during this term of our office. It mustn't be prolonged. Well, remember the committee previously even requested. Yeah? The committee requested.
Well, I was apologizing, Chair, for.
Now, what we were dealing with, and we wanted you at the end of the day to finish up with it. It's this section 24, which Liz has already touched it, but we also wanted to give you some input in terms of, we understand that you have made mention that we have to, you give yourselves redrafting, and also we can adopt it with amendments in terms of that. But I think Lisa has not rejected or against us as the committee in terms of how can we deal with that clause and that section.
Chairperson, it's not.
Nati?
So thank you for the guidance, Chairperson. I am going to be, thank you, Chairperson. I was saying, Chair, I will work with my colleagues who have been part of the committee's discussions to give effect to the committee amendments with respect of the before. Thank you, Chair. But I was attempting to all of myself in respect of decisions that might be given to us as drafters as to how we're going to implement them. So, Chairperson, now I follow your guidance in respect of 24, that I will liaise with my colleagues and will give effect to committee's discussions. But this is in respect of that clause. Thank you, Chair.
Okay. Can I then, I see hands. I don't know whether it's still old hands or it's new hands. Can I get the indication? I see Marie's hand, Honorable Marie, Honorable Bridget, Honorable Alex. Those are the last hands, honorable members. Over to you, Honorable Aibo. Okay, it was old hands, but now it's new hands. It's Honorable Masango and Alex. It's new hands. Then can we continue, honorable members?
Okay, Chair. Thank you. Sorry, I'm sorry for saying okay. So I formally then propose that on section 151A, we need to change the wording to read as follows: orphaned or abandoned and not in the care of the family.
Alex?
Thank you. Yes, thank you, Chairperson. I was going to suggest something else, that it reads, let me just get my bearings here quickly. You can just move on to Honorable Stock quickly. I just want to get my bearings, Chairperson.
What are you saying, Alex?
I'm just trying to find my place. You can move on to the next speaker quickly.
You want to find your place?
Yeah, my notes quickly, Chairperson. Just give me a second. You can move on quickly.
I want to wait for you and then give over to Stock after you have done.
Okay, so I heard what Honorable Masango said with section 150, but I almost want to reword it a different way, and then I'll just also take guidance if maybe I should not also just submit it in writing. But then has been abandoned or orphaned and has no parent or guardian and is not in care of a family member as defined in section 1. And then also lastly, Chairperson, I didn't hear the advocate speak to the timeframes in terms of section 1592A as it is done with 2B. I did make a comment in the chat box. Thank you, Chair.
Honorable Dukham.
No, thank you very much, Honorable Chairperson. I wanted to make a proposal. Also, time at which we spent already on this proposal, whether to amend the wording to this, like Honorable Masango was proposing. So I wanted to propose, Honorable Chair, for the sake of progress, I wanted to propose that because there are also different interpretations and different understandings on the wording, maybe the proposal which is made in terms of, which was made by Honorable Masango, with regard, I think it's section 24. I will propose in the meeting that we take it for now. We don't agree to it for now. Let me use my word. Let me clarify myself very well, because I know if I don't clarify myself, there will be a video that will go to political parties, and then there will be articles and so forth. So I must phrase my words very clearly so that all of us were clear in terms of what I am saying in the meeting. I am saying Honorable Masango is making a proposal in the meeting. Now that there are different proposals or different interpretations, it's difficult for us now to come to a conclusion and say whether we agree or we don't agree. So it will be fair enough now to maybe give it to us so that we all apply our mind, look at it, and then what was the insertion in the bill and also in this A list and all of that, and what Honorable Masango is proposing. Maybe in the next meeting, we are able to come up clearly and start with section 24 based on the proposal that is being made by Honorable Masango. Because otherwise, we are just going to rush into agreeing or not agreeing on something which might make sense or something like that. So I'm just proposing that maybe it's a food for thought. Let's consider it for now. Let's take it for the next meeting, so that in the next meeting, then we get clarity on section 24, we finalize it. But we then move to propose the adoption of the A list on all the amendments that were done, excluding this one of section 24. Section 24, we'll consider it in the next meeting. I think that's the proposal that I wanted to make, Honorable Chairperson. Thank you very much. Thanks.
Honorable Mangani and Honorable Msong.
Honorable Stock. This one will leave it. The section that Honorable Masango was proposing. We can't take decision without going through it. I support Honorable Stock that we will deal with it in the next meeting. Thank you.
Honorable Msong.
Thank you very much, Chair. I also wanted to agree with Honorable Stock that the proposed amendments in section 24 be dealt with in the next meeting, as he has alluded that we need to go and further consult about it before we engage now, without understanding properly what Honorable Masango was saying. And also, Chair, I would then second him also, because I heard him moving for the adoption of the proposed amendments, except the one of 2024. Thanks.
Sorry, Chair.
Honorable Sukers.
Okay, it was me, but
I'll go after Honorable Masango, if she can proceed, Chair, if she was before me.
No, man, no. Allow me to take this meeting. Go on, and then I'll give over Masango.
Yes. Yes, Chair. Madam Chair, I just want to ask, the clause 24 was proposed and it was seconded by Honorable Breed. The state law advisor has advised the committee on clause 24. I just need clarity. Is Honorable Stock saying that referring to clause 24 as I have proposed and as it was seconded and then clarified by the state law advisor, that be included in the exclusions, and that only what was initially then being presented to us in essence be adopted by the committee? I just need to understand that, Chair, please. because that takes us right back to saying that regardless of all the deliberations that was done here today, what was then just presented to us, we need to, as a committee, then conclude, and all deliberations that was made is then ignored. I just need to understand.
Okay. I think it's old hands. You know, honorable members, you are really putting me in a dilemma right now. I am interested to get the advice from our Mjengane again, and at the end of the day to concrete and finalize at least this part, which we will adopt it and agree that we will again get a bill list where the advisors requested to redraft. So can I, because I don't want to always take a discretion in a meeting. I'm supposed to have chairing, but I am also have a right to also advise the meeting when I see that the meeting is going Can I give it to Mjengane once more?
Chair, Mjengane is going to join now, Chair, in a minute.
Yeah. How is he going to join?
Okay.
Hey, this thing here virtually, when we are dealing with things like this, it's really complicated.
Mr. Mjengane? Yes, it's over to you.
How are you going to hear what we saying? Usivile, because now there are two views. The other one is saying we can adopt this with amendments. The other one is saying let's rather put 24 aside and look at it later on to take the decision on what has been said. Kanti ebesithini u-24 initial. Sele now that we are changing it and doing this and that, sasingavumelananga kuqala, why still u-24? Knowing that at least deliberations can continue, we can discuss it and discuss it again and again. Can you assist us?
Thank you. Chairperson, the issue of 24 and the deliberation and proposal by members to further amend it is a matter that is possible to do with having adopted the rest of the other clauses that are not in contention. And that's what we would do technically to assist the committee around the suggestions of 24. We would go and look at the proposals of members and try and craft them technically into a workable amendment that we will take in the committee together with the B version, which is the rest of the accepted amendments. So on that day when we present the B version, we can table our, of course we would have had discussions with the members who've proposed the changes, Chair, and craft a provision which can be discussed by the committee in the next meeting when it considers the B version. If the members are agreeable in that meeting, the next meeting of the committee concerning the B version, we will simply just include 24 to the agreed 24 now to form part of the rest of the process of the B version, so that it doesn't delay the rest of the committee.
Okay. I think members are able to hear clearly. And also Honorable Alex, who wanted also to rephrase it in a manner and requesting to send it in written form. Maybe if we all can also wait for that meeting and then look at the rephrasing or redrafting that you'll be doing, and then it will be Alex's opportunity to say, no, I would like this to be rephrased like this, or rewrite. How is that, honorable members, rather than to go backward and forward and backward and forward? Because right now we discuss all these things and we agreed, and we had to say, let's adopt it as it has been put forward, but get a redraft and also the B list. Honorable Stock.
Oh.
Who's that? Masango?
Yes,
Is it
Chair.
Masango? Okay, Honorable
Yes.
Masango.
Yes, Chair, you were about to give me an opportunity to speak. What I wanted to be clarified as well was that, for example, I would like to, my proposal is that we give all, whether the chairperson decides that it's in writing or not, that I agree with the process of the drafters going away, considering what we have raised today as members, and then saying what it is that can be done, if anything can be done at all, and then coming back to say, this is what the members said, and this is what we've gone away and considered, and we sort of recommend that it be drafted like this or not like that. And then on that basis, we have a full A list that needs to be now approved by members, because I don't know that we can approve the A list and then still go away and do other things. I don't know that is even procedurally sound. So that is my proposal, Chair. That is my proposal. We just say, for example, 21, 24, 160, 150, 159, and whatever, everything that we've said today. And then the drafters who have been in the meeting throughout, and the chair who presided over all that, they go away and say, this is what was said, this is what we can advise on, and bring it back to the committee, and the committee then looks at that, and then on the basis of that, we say the A list has been deliberated upon and advised on by the legal advisors is like this. So members, please, can you take a decision, and we take it from there. That would be my proposal, Chairperson. Thank you.
Okay, I think my battery is going low now. Can we then go and step away from this item now, and then come back and adopt it? Lindy, are we in a right direction when we say we will adopt it in the next meeting? Looking at this section 21 or clause 24, I mean 24, not about 21. Then the redrafters or crafters, all those that think would like to have this, are taking us to that situation right now, and step away from this and get into the next item. What is the next item?
Chair, can I comment on that?
Comment, Assessor.
Okay, as well. I think, Chair, you are in a right direction by deferring the adoption, now that there are a number of issues raised as far as the A list is concerned. That will be proper, so that by the time you see the A list, and then there will be a B bill to cross-reference what you have agreed on, whether it appears in the B list. So, Chair and members, I don't know, because we targeted next week, Friday, to complete the process. How if we can meet on Friday this week to adopt the A list, so that we know where we are within our time frame to finalize the bill next week, Wednesday. I just wanted to put that proposal.
Thank you very much. I think, Lindy, you are in order. We have to have this. Remember, this is a recess or constituency week, we requested a special slot. You have also to apply again for the permission to have these meetings that are outside. But because the process is dragging and we have to finish it, we're not going to ask any extension again from the High Court. It will be really an embarrassment to us, as it will be an embarrassment to not to finish this during our term. We have to finish it during our term. So can we request the members to go to the next item? The next item is, what's the next item? We have deferred this one over.
Okay, to next week or Friday, Chair?
Friday. Even if myself I'm tied up, and can we, because we have to, because Kaloku are prolonging and it disturbed the program, the one that we have drafted.
No,
Yes.
I'll submit an application for Friday. I don't think it's going to be a long meeting. Chair, the next item is the adoption of three set of minutes. The minutes of the 25th of May and the 1st of June, as well as the 3rd of June. Those are the three set of minutes scheduled for adoption, Chair.
Thank you very much, Lindy. Can you flight the first set of minutes? What date is it?
25, Chair.
25?
Yes, Chair.
Can you flight them?
Chair, this date, the committee met at Taj Hotel to deliberate and inputs on the Children's Amendment Bill. There were members from the ANC, was member you, Chair, member Mvana as the chairperson, member Stock, Hlongo, Manganye, Mutaung, and Bilangulu. From the Democratic Alliance, we had member Masango, member Brahms Opperman, and then from the Economic Freedom Fighters, we had member Iris, member Mare. From the Inkatha Freedom Party, member Fana Merve, and member Sukars from the ACDP, and then as well as member Brett from FF+. We didn't have any apologies, Chair. There were three legal officials from the department, and also the state law advisor who were in attendance. Chair, I don't know whether to proceed because members Abraham hand is up. Must I proceed or you want to attend to that?
Lindy, proceed.
Chair.
I'll give her an opportunity.
Okay, Chair. At this day, Chair, the member, the parliamentary legal advisor proceeded with the presentation of the 12 clauses, and then he referred to also the public participation process, and also the clause by clause. And then the reference was also made to the Principal Act, as well as the current deliberation agreement on clauses to be presented. There were the deliberations that ensued, Chair, where the committee took clarity whether the committee on its previous meetings reached the conclusion around 21 and section 24 in addition to the 12 clauses. And then there were also a request for verification of minutes of the previous meeting. Unfortunately, I was not part of that meeting. I was writing exams. Also, there was also a resolution that the previous to confine itself to the foster care clauses, and also also there should be a reflection of their inputs, and also there were no further inputs by members. The resolution taken on that meeting, the committee agreed to the 12 clauses amending the children's amendment, the children's amendment bill, which means the foster care clauses. And also the committee resolved that after complying with the court order to revisit clause 21 and other sections of the bill which did not find the desired expression in the current round of deliberations. And also clause 21, which deals with custody of children and unmarried fathers, needs an and extensive public participation process and broader participation, which could possibly also to include consultation with the House of Traditional Leaders. The committee agreed to the finalization of the A bill for presentation and consultation in the following meeting, which was supposed to be the first. Chair, those are the minutes of the 25, Chair.
Okay, thank you. Thank you, Lindy. Alexander, Honorable Alexander's hand is up, and it was up before.
Yes, thank you, Chairperson. So, Chairperson, there has to be a clause in this minutes that state which members left the meeting. And the reason I say that is because the minutes as is would therefore be misleading. And I'll take myself as an example. I am minuted as being in attendance, but I had no partake in the resolutions and that was in these minutes. So therefore it gives the impression and the incorrect information that I was in agreement and part of the entire deliberations and part of the resolutions. And now that is misleading. So, and it's not factually correct. It's not a true reflection because I wasn't there. So I'm of the opinion, and I must insist on it, that then the members whose attendance were recorded in the beginning, there needs to be a paragraph before the resolutions to say that they've left the meeting and therefore were not part of the resolutions, because that would then be a true reflection of the meeting, Chairperson.
Thank you. Noted. I see the other hand. Is there not a place where it is said that they left the meeting? Lindy, is there nothing
I'm just trying to read, Chair. Yoli, when you edit, there was nothing that speaks to the members who left the meeting. I don't see.
No, there wasn't.
There wasn't.
Okay.
No.
Okay, it's fine.
We can edit. Yes.
Yes. Okay. Jane? But in presence, they were present in the meeting and then they left the meeting.
Yes, Chairperson. So my proposal is that the members who left, their names actually need to be in the body of the email before, middle of deliberations, but definitely before resolutions, because we weren't there for resolutions.
Thank you, Alex. Don't repeat yourself. I haven't given even you, but I said I must wait for you to finish up. Your concern and also your input has been noted. That's why I was requesting and checking from the secretary whether is there anything that is saying. Thank you very much. Jane Mangani.
Thank you, Chair. With the amendment that shows that they left while before resolution, okay. It should, and then the minutes will be incorrect. It will be correct. I move
corrected.
Move with that. Thank you, Chair. I will move for the adoption with that. Thank you.
With that amendment. Thank you very much, Jane. Marie, followed by Stock.
Yes, Chair. I want to make a note, Chair, that the way it says committee deliberations, there are certain deliberations or certain comments that are not reflected in the minutes. And I remember very clearly that the points of contention was, and my point of contention in that meeting was that the committee needs to apply itself, its mind, and deliberate on the real impact of the legislation that we are busy working with. And it was following my assertion that we are not, in fact, doing that. When we looked at and the importance of clauses 21 and its impact on specifically children that goes into foster care, where there is and the impact on the foster care system of keeping children in foster care who does not need to. as well as, and I'm sure the objections or the comments made by the other members that has also left, because we left for a reason. And it was because we felt that the committee was not considering was not deliberating at that point around the real impact, the practical implication of just omitting the sections that was under discussion at that point, as well as the biggest issue, which was the contentious point around section 21 and 24 as per the previous meeting, and what was meant by, yes, Chair, I think I need to stop there.
Yeah, please stop there, Honorable Sukers, because we're not going to rewrite the minutes, but the only thing that we will do is to put or try to cover up that thing of members who left the meeting. And in that meeting, we even said in the following meeting, we cannot not read the minutes. And yes, we said we cannot stop reading the minutes because of the absence of one honorable members. We have never done that. But we have taken notice of exactly that this issue of honorable members, which needs to be listed, left the meeting, which we agree on that one and will be corrected. Otherwise, we're not going to rediscuss and rewrite. Thank you ever so much for noticing that that hasn't been included in these minutes. Honorable Jane. Okay, wait, so that I finish up other members and then give you. Okay, let me give you, because it's you and the last person who's going to be Honorable Stock. Otherwise, the minutes have been proposed to be adopted with amendments. The one of at least including this thing, as Alex and also yourself has put.
May I proceed, Chair?
Yes, proceed, Honorable Sukers.
Yeah, I wish for my objection to be noted, Chair, and it is for this reason, that it is not just the fact that I'm not opening a discussion or rewriting the minutes. I think the principle around the why of the members walking out is important, and it should be noted. We cannot rewrite what happened on the day. The principal issues around why members were in fact objecting or protesting in the manner that they did should be noted. And so for that reason, I object to that, Chair, and I wish for that objection to be noted. Thank you.
Thank you, Honorable Sukers. Honorable Stock.
Thank you very much, Honorable Chairperson. No, I think I agree also, before I move to second the proposal made by Honorable Manganyi. I just need to agree with you, Chairperson, that indeed we're not rewriting the minutes, and then we're not opening up discussions by presenting the minutes in the meeting. I think it's a very important and fundamental point that you have raised. And I think it must become a cornerstone of our engagements in the meeting when we deal with minutes. Because why I want to emphasize that point is that honorable members will lose debates. And then when they have lost debates, when they left, and then they leave meetings, and then they come for us to open debates in the minutes. And I don't think it's fair. I just wanted to raise that, and also just to emphasize the point that we're raising. It's a very good point that we raised. Thank you very much for that, Honorable Chair. And then, Honorable Chair, in as much as we are going to put the issue raised by, proposed by Honorable Abrams, that honorable members who left before the resolutions were taken, we also need to put in the minutes that we did not know the reasons why they left the meeting, because we were in the meeting and then honorable members just stood up and left the meeting. And then after a few minutes, Honorable Abrams came back to the meeting and then requested your audience, and then she then raised the objection that no, I just wanted to note that I'm leaving the meeting, but she was not raising the objection on behalf of the group. She was raising the objection in her own personal capacity as a member of the portfolio committee. So others that left, as things stands, they just stood up in the meeting and then they left. So we don't know why they left. I just wanted also to bring that point to the meeting. Thank you very much, Honorable Chair. I move for I second the proposal for the adoption of the minutes as a true reflection of the meeting. Thank you very much, Honorable Chair.
Thank you very much. I've noted.
Chairperson, my hand is raised.
No, I see it. I have opened my gadget, honorable members. Allow someone or a person to chair the meeting. And then if I leave someone behind, definitely I will have to go. It's in front of me. I've noted the input from Honorable Sukers. She must also, lower her hands now. But I see new hands now. Maybe they also want us to note their disagreement or rejection or whatever. Maybe I should give them to speak on this. It's Bridget Masango, Honorable Bridget. It's Bridget. It's Aris, because Alex has put it forward and reminded us that in the minutes there's nothing that is saying that they left the meeting. Then we continue with the meeting because we had to continue because quorum was there. Bridget.
Thank you, Chair. I just wanted to register my objection to the minutes and not open any discussion other than to say that it is very, very, very interesting and fascinating that the Honorable Stock keeps saying that when we lose debates, we leave the meeting, but he doesn't know why we left at the same time. Chairperson, I thought that we were in a meeting, we were not in a debate. And there was a long discussion that ensued. And the minutes say that the discussions ensued, but when it comes to the deliberations, they do not reflect. And this is the first time I've ever questioned the minutes of the meeting of this committee in 8 years. And I just want to place it on record that it is very interesting that the issues start where we leave the meeting and nothing before then. And we are not abnormal people that will just up and leave the meeting. And I believe it is very, very unfair and it's very irregular that we are recorded. And now we are going to be recorded as such to say we just left the meeting because we left, in the words of the Honorable Stock, because we lost a debate. We did not lose a debate. The discussions in the meeting reached a stage where we were being forced to not be listened to, but to actually expunge an entire section of the minutes of the previous meeting because the secretary was not there. And to this day, those minutes are not a reflection of what had happened in the meeting. And so, Chairperson, I strongly object to the minutes, and I would like that to be recorded. Thank you so much, Chairperson.
Thank you, Honorable. You have been recorded, noted. Honorable Brett.
Thank you, Madam Chairperson. Madam Chair, let me, I don't think I can say it any better than Honorable Masango has just said it. I think we were clear in the reasons that we left, and I would please like to register my objection to these minutes as well, as I do not see them as a true reflection of what happened. Thank you.
Thank you, Honorable Brett. Noted. Honorable Aris.
Yes, thank you, Chair. Chair, please note the objection of the EFF, as this minutes is not a true reflection of what has transpired in the meeting. Thank you.
More than recording as EFF, but recording as Honorable Aris. Thank you very much.
As a representative of EFF.
Yes, thank you very much about that, of reminding us that you represent. We are a family. You open a meeting as such. We are still a family. Honorable J and Honorable, who's this? Lizelle, and then Honorable Kate.
Chairperson, my hand is also up.
Again, let's first give those that couldn't manage to speak, Alex. I am not intentionally skipping you, but I'm looking at the hands that couldn't manage to have a bite on this thing. You were the first one to have. I will give you the second round if the time allows us to do that. So don't panic. I'm giving Honorable Lizelle and then Honorable Kate.
Thank you. Thank you very much, Chairperson. I have been covered by my colleagues. I really do not appreciate the very confrontational stance that the Honourable Stock keeps on advancing in this meeting. It was very clear that we left the meeting because we felt that we were not finding each other on clauses that we had agreed to in the previous meeting. So our walking out was in protest of that, which is our democratic right to do so. And so I would also like to record my objection to this set of minutes as not being a true reflection of what transpired on the day. Thank you, Chair.
Thank you very much. Noted. It's just that it's a pity that it was going to be better if it was cleared before. But nevertheless, it's never late to mend. You are explaining why did you have to leave. Kate, Honorable Bilangulo.
Thank you, Chair. I think there is no problem here, Honorable Chairperson. But the issue is honorable members were in the meeting when we started with the meeting on the set date. But they left. I don't want to get into the issues as to what makes them to leave the meeting, since they didn't indicate on the same date that the reason of their leaving, except Honorable, who's this?
Sukers.
Alex.
And Sukers.
Alex.
Honorable.
Alex, okay.
Okay, except those who did mention that they are leaving. But after leaving the meeting, they left other members of the committee in the meeting. We proceeded with the meeting because we were still a quorum. And by virtue of a quorum proceeding with the meeting, to me, with my little knowledge that I have, it means we proceeded with the meeting. Therefore, the minutes that are before us today being presented, it means we are going to adopt the minutes as members of the portfolio committee who were left behind proceeding with the meeting as we were forming a quorum. Maybe I will agree with honorable members to say they recuse themselves in moving for the adoption and seconding since they left, but they were there. So I will support the issue of adopting the minutes today. Thank you, Chairperson.
Thank you, Honorable Kate. The minutes.
Chairperson.
Who's that now?
Sorry, I just need to get clarity because I did indicate that I will leave the meeting, but I was muted in the meeting, so I just need to clear that because I was muted on the virtual platform.
Okay. It's our first time to hear that. I don't know what happened, but it's noted and it's
I was
recorded.
I was screaming even, but you muted me. They muted me.
Okay, thank you very much. The minutes have been adopted and seconded by Stock and also adopted by
Mangani, Chair.
Mangani. Thank you very much. Let's pass this now and go to the next set of minutes.
Chairperson, I can't pass it, and please give me an opportunity.
Okay.
So, Chairperson, the reason I can't pass it is because the Honourable Stock made special reference to myself. And you have just said that we can't rewrite minutes and can't rewrite history. But in this very meeting now, the Honourable Stock rewrote my own history and my own actions. I did not leave the room and come back, as he has just said now. I was still in the meeting when I spoke to you. So I think we're setting very dangerous precedents here, Chairperson, where other members of the committee can firstly say what members said in their absence and then rewrite what members physically do in meetings. And I take strong exception to another member saying something that I didn't do. So, Chairperson, I now made suggestions, and it didn't have to go this way, but the Honourable Stock, I don't know what's going on today, has made this meeting now go this way, and therefore, with my amendments, I will still then object to this minutes as not being true reflection of the meeting. He cannot rewrite my history while I'm still in the room and on the virtual platform. It's totally unacceptable, Chairperson.
Thank you, Honorable Alex. We have noted you. You were the first one to say, and you are right. I asked you, where are you going, honorable members? Can you be able to just stand up and walk? That's what I am, because I don't even want myself to rewrite and go back to that meeting. Can we proceed, honorable members? These ones, the one that were present, have adopted the minute and also seconded the minutes. Can we pass to the next set of minutes? Lindy?
Oh, Chair. Okay, Chair.
The next minutes, what's the date?
Is the first, Chair, of June.
Proceed.
Okay, Chair. In this meeting, Chair, the committee was scheduled to receive a briefing from the Department of Social Development on its first to third term quarter report on financial and non-financial for 2021-2022, which is it's a quarterly report from April to December 2021. We also adopted minutes in this meeting. Members that were present and who left is Member Mvana, some of my members left. Member Mvana, Pilankulu, Member Manganye, Member Mutaung, Member Stock, Member Hlongo, and we have Member Abrams from the Democratic Alliance. We have Member Aris, Member Mare from the EFF. We have apologies from Member Masango, Member Opperman, Member Sukars, as well as Member Vanda Merwe. We've got departmental officials who attended, as well as the support team from Parliament, and the chairperson welcomed everyone. And then the apologies were received from Member Masango, Member Opperman, and Member Sukars, who were unable to attend the meeting due to political party prior commitments. And also Member Vanda Merwe, he attended until 11 o'clock and attended a doctor's appointment. Also, the minister was not present. She attended a presidential economic retreat, and we adopted the agenda. And the proposer was Member Vanda Merwe, and then Member Manganye seconded the proposal. And then we tabled a set of minutes for the 4th of May, which was adopted by Member Hlongo, also seconded by Member Stock. And then we also adopted the minutes for the 11th of May, whereby Ms. Member Pilangulu moved for adoption and seconded by Member Stock. For the minutes of the 18th, the minutes were tabled for adoption. And also there was a concern raised of the previous minutes, which did not reflect resolution taken by the committee to consider clauses 41, amending 21, along with 12 foster care-related clauses. Also, emphasis was made that the minutes are crucial record of committee and are considered as source documents in courts and in commissions of inquiry, and so they must be a true reflection of the proceedings. The committee was urged to watch the video of proceeding, which showed that the committee took a resolution to consider clause 10. There was also a view that the committee has a right to deliberate and rescind on its decision. The committee was also reminded that at the end of the meeting in question, the committee resolved to restart the clause-by-clause process as the committee had not considered the matrix with inputs from the stakeholder and responses from the department. The department was also the meeting was also reminded that the committee would still consider the clause 10 as part of the Children's Second Amendment Bill. Mr. Stock proposed that the video will be played, and his proposal was seconded by Ms. Manganye. Ms. Iris also proposed that adoption of the minutes should be deferred to the next meeting when Ms. Van der Merwe would be present, as she was the one who proposed that the clause-by-clause consideration of the bill should start afresh on the 25th May 2025. Ms. Brett seconded the proposal. There was also a proposal to refer the matter to the legal advice from Parliamentary Legal Advisor. Mr. Mjengane stated that the minutes are a record of the committee and there is no rule that excludes the viewing of the video. Listening to the video would give clarity on what transpired during the meeting of 18 May 2022. It would assist the committee in reaching a conclusion on the matter. The legal implication on the decision taken on the 18th is that it was up to the committee to start afresh, which is the novel in Latin word, the clause-by-clause consideration, which it did not on the 25th of May. With this decision, legally, all the resolutions that were taken prior to it would not stand. Ms. Iris, Ms. Abrams, and Ms. Brett expressed their views, noting that the minutes were not true reflection and what transpired in the meeting in question, and rejected the minutes. The committee proceeded with the video. Thereafter, Mr. Talk moved for the adoption of the minutes as true reflection of the meeting with amendments, and the motion was seconded by Ms. Flongo and Ms. Flongo. The minutes were adopted with amendments, and then we went to the briefing by the Social Development, which is the department. Mr. Linton made an overview and contextual analysis of the department's performance from the first to the third quarter. He explained that the reporting period concluded one of the most difficult years as a result of COVID, and also that the department achieved 76% of its target, and also under those circumstances was an indication that it was a learning organization that builds from the FEM Foundation. And also, he mentioned that the department adopted a result-based approach in order to demonstrate the impact of its intervention. And also, they gave us what was available, what was allocated, available budget, and how the money has been spent. But at the end of second quarter, July to September, the financial year, the department spent 107 billion. And then the discussion on these three reports will be contained on the committee report on the department's financial and non-financial performance, which is scheduled to be adopted next week. Thank you very much, Chair. And members.
Chair. Hello. Chairperson, may I quickly address you, please, on the minutes?
Yes.
Chairperson, it is reflected there that Liesel van der Merwe said that we have to restart the clause-by-clause process. In fact, when we were having the discussions, the words that I used was we will have to restart the process. But my reference was to the fact that
On a
at
point
that
of
point,
order, on a point of
No,
order,
I'm on
Honorable
the
Chair.
floor. I'm on the
On
floor.
a point of order, Honorable
I'm on the
Chairperson, can I
floor.
just raise a point of order, please?
I'm on the
Procedural in terms of
floor. Can I please
procedure.
complete my sentence? I was
Honorable
referring,
Honorable
I
Chair,
was
can I please
referring
raise a
at
point
that
of order?
point to the fact that we had realized that we were working from an
Honorable
old
Lizelle.
document. Chairperson, I'm not going to,
Honorable
if this is
Lizelle.
the way the Honorable Stock will treat us, I will refer this matter to my Chief Whip.
Can I raise
I
a
had
point of order,
referred-
Honorable Chair, please? Please.
Honorable
Please.
members.
Chairperson, you have to
Can I-
protect us. We cannot be
Honorable
bullying
Chair.
the Honorable Stock. You have to
Honorable
protect us,
Chair,
Chairperson.
I'm not bullying anyone. It's within my right.
You are a
I'm
bully.
part of the
You
meeting.
bully us.
No, I'm part of the
Honorable,
meeting. I'm part of the meeting.
don't do the dialogue.
But Honorable Stock,
No.
I'm trying to explain what I was referring
Honorable
to.
Chairperson,
At that
can I raise
point,
a
we
point
had
of order,
realized we were
please?
working from an old document. And
Honorable
I said,
Chairperson,
we
can
have
I
to,
raise a point of
we have
order,
to
please?
start afresh.
Honorable Stock.
Chair, but you
and
must,
Honorable
Chair, you are the chair of this meeting. Why can't you call the Honorable Stock to order while there's
Lizelle,
speaker on the
Honorable
floor?
Lizelle. No,
How
no.
can I explain myself when he's speaking?
I want to raise a point of order. I've raised my hand. I want to raise a point of order, Honorable Chairperson, please.
You know, this means you are really disregarding me as the chairperson.
Yes,
If it
please,
is the
Chairperson,
case,
please rule.
you have to continue with the meeting without me. Honorable members, I'm saying honorable members. I'm not saying honorable so-and-so and honorable so-and-so. I'm just saying honorable members. I'm referring to both Honorable Lizelle and Honorable Stock. Avoid this thing of when someone is speaking and the other one wants to speak. And avoid, honorable members, to want to make a dialogue when someone is speaking. Please, honorable members, respect the meeting, respect myself, respect yourselves at the end of the day. Please, honorable members.
Can I
don't
proceed
even
with the
know.
point of order, Chair?
Chair, I will then put
can I
my
proceed with the
clarification
point
in
of order?
writing, and I will refer it to the Chief Whip that the Honourable Stock has not allowed us to give clarification on issues, because I feel that the way that he is treating us currently is not how we should be treating on each other, because we never disrespect him and we don't treat
Honourable
him with
Chairperson,
contempt.
Can
Thank you,
we-
Chairperson.
can
I
I
therefore
please raise a
object to
point
this
of
set of
order?
minutes. Thank you.
Can we
Honourable Chair,
then
can I
wait
please raise a
and
point of
wait
order?
for one another? Are you done, Honorable Lizelle? Then over to you, Honorable Stock. Oh my God.
Thank you very much, Honorable Chairperson. Honorable Chair, I raised my hand because I wanted to raise a point of order. I think now, Honorable Lizelle, I'm not going to refer what she said about me. It's fine. That's how she perceives me. And I'm not going to waste my time to respond to all the issues that she's saying about me. But I'm in a meeting. If a member is out of order, I think the rules of parliament allows me to raise a point of order in terms of the procedures. So by doing so, I'm not bullying anyone. The point of order I'm raising on here, Honorable Chairperson, is that Honorable Liz van der Merwe, it's captured in the minutes. She was not part of that meeting. So how can we allow her to speak on the minutes where she was not part of? That's the point of order that I wanted to raise. Thank you very much, Honorable Chairperson.
I was part of the meeting till 11 o'clock.
Hello?
Chairperson?
Honorable members.
Chairperson?
You know, this thing disturbs me a lot. You know, we have to respect one another. You know, the way I respect you, you must as well respect me. When I call you to say that at least stop what you are doing, you must at least respect me. This is really starting. It's a beginning, and I know for a fact that it will continue. But I'm not going to allow it to continue. We were on these minutes. Honorable Lizelle has already indicated that she be noted that she rejects this. I've noted it. Can we then give over to whoever's hand is up? It's Honorable Sukers and it's Honorable Abrams. Briet, and it's Honorable Aris. Then, and Honorable Shaw. I've given you Honorable Lizelle. I'm sure it's the old hand. Can we then proceed, Honorable Sukers? If it's a new hand anyway.
It is a new hand, Chair.
Okay.
Chair, I think we need to resolve that we are going to resolve this matter, and I think it depends on the maturity that we are going to display. The issues that was raised as per the minutes, as what Honorable Van der Merwe said, those issues are around clauses. There's a reason why each one of us have a position on it. The most important was the impact of children within foster care. If we retain the whole issue around what the difference of opinion was, we will be able to harmonize this committee again. However, we cannot allow that members be not feel heard. And that is what is coming out in this meeting. I fully agree, Chair. You are the chair of this committee. We need to respect you. We need to reset the way that we do things, but we cannot allow for members not to be heard. And it's substantive, the issue that is raised by Honorable Van der Merwe. It is not substantive because it is a political matter. It is substantive because it deals with process, number one, the parliamentary process. And then secondly, it deals with the issue of the constituency, which is the most vulnerable, which is children. So let us just come together on those 2 points so that I don't want to mention names, so that people do not react politically or unilaterally in order to suppress the voices of other members. I think it is a very important point. Otherwise, things are really going to get off the rails. I agree with you, Chair. But I want to make those things around those 2 issues. And members need to understand this is a democratic process. Every single voice that is part of this committee needs to be recognized.
Thank you. Thank you, Honorable Sukers. I think the hand of Honorable Briet is up. Can you lower your hand, Honorable Sukers?
Thank you, Madam Chair. Madam Chair, firstly, on page 1, where it says attendance of members, I'm not reflected there as attending. And I think that just needs to be added as it is imperative to the rest of the minutes where I am made mention of. So just that correlation, Madam Chair. And then just, Madam Chair, I would like to second what the Honourable Sukert has said. I think Liesel, Honourable Van der Merwe, wanted to provide clarity, and I think we need to, as members of this committee, whilst we are dealing with minutes, Madam Chair, you will agree that minutes of these committees can be detrimental in court cases, can play roles that go larger than this parliament, than this committee. And I strongly agree with Honourable Sukers that when a member objects to something not being as a true reflection of what that member said, we should allow that member to talk in this sense. But Madam Chair, thank you. I do agree that we need to harness it back to ensure that this committee does not become a full-blown circus. So I would support you with that too. Thank you, Madam Chair.
Thank you, Honourable Briet. Honourable Mhlongo.
Thank you very much, Chairperson. As a person who was part of that meeting on the day, I want to adopt the set of meetings as presented by Lindy Chair.
Okay. Thank you, honorable members.
Chair, sorry, I've lost connection.
Sure. Now you are back, ne?
Yes, I'm back. Oh. Sorry. Yeah,
Okay.
it is load shedding.
So your hand is up. Is your hand
Yes,
up?
my hand is up. Yes, my hand is up the whole time, Jay. It's load shedding with us. Yeah, thank you very much, Chairperson. Chairperson, I was in that meeting and I was the one that was proposing that if you can see in the minutes. I think it is just more than right, because in that meeting, I can recall there was a lot of backwards and forward, and that's the reason why I did make that proposal. I feel it is really unfair. We have an opportunity. Honorable Liesl van der Merwe is present in the meeting to clarify this issue, because right now you want us, to accept the minutes of that is in front of us, but it is not fair the way Honorable Stock is treating us. Honorable Stock need to understand that it's our right to differ, but we need to be respected. Honorable Stock also need to understand that he is a whip of the ruling party, he is not the whip of the opposition parties, and it needs to be respected. It don't mean that he's the only male in this committee. He can bully us as female counterparts in this meeting. So I just want to clear that one. Thank you, Chair.
Thank you, Honorable Sukers. I don't even want to go back to where we are from. I would like us to say that we've noted all the concern of other honorable members, and worst part of it, Honorable Mhlongo has raised her hand and say, let's accept those that would like to be noted that they are disagree with the minutes. It's fine. We have noted here, and they are recorded on that. Thank you ever so much. Honorable Mangani, I can see that your hand is up.
Yes, I was seconding Honorable Mhlongo.
Honorable Mhlongo has been seconded. Can we then go to the next set of minutes? Honorable Member is the last one. Sure. What?
Chair, the set of minutes was the 3rd of June. Also, I was not present. I was writing exams. Hanim was an acting secretary. On this day, the committee was receiving a briefing from SASSA and DSD on the new regulations on the payment of the Social Relief of Distress SRD grant. Members present were you, Chairperson, Member Mvana, we have Member Stock, we have Member Mutaung, we had Member Mhlongo. From the Democratic Alliance, we had Member Masango, we have Member Abrahams, we have Member Opperman, and then from the EFF, we had Member Iris, we have Member Mare. From IFP, we had Member van der Merwe. From the Freedom Front Plus, we had Member Priet. And then we only received one apology from Member Sokers. And then we had departmental officials as well as the support staff of this committee chair. And then you welcomed everyone and then presented the agenda, which was adopted by Member Stock and seconded by Member Abrahams. Also, in your opening remarks, you also mentioning that we need to remember the Youth Month, and we called on the committee and the rest of the society to assist the unemployment youth and the fight against violence and murder of children in South Africa. And then we had the minister who made a number remarks overview. Chair, sorry for that. And then we had a minister who made some remarks as well. After her remarks, the department and SASSA made a presentation. Just hold. which also briefing by DSD on COVID-19 RSD regulations. We had member Linton, Mr. Linton, the ADG, as well as the Mr. Van Friede, the Chief Director of Social Assistant, and Mr. Director for Social Assistant, as well as the DDG, Brenda, also briefed the committee on the new regulation regarding the payment of the SRD grant and other social grant. And then a copy of the presentation was available for members who want more detail on the presentation. The deliberations that ensued pointed out that at certain Pick n Pay outlets, elderly people were made to wait for long hours for the payment of their grants due to technical issues, and asked how well the system of utilizing outlets to disperse social grants was functioning. Also, Mr. Fred made reference to the readiness of the system, that the regulation form part of government realization of the benefits provided by the SRD to the rest of the society. And he went on. And another issue that was raised, the committee wanted to check measures that have been put in place to ensure that beneficiaries who live in rural areas without retail outlets have access to their social grants. As well, they wanted whether SASSA, the plan was to address the lack of doctors to conduct disability assessment at the Pekhalstop Community Health Clinic, and without an assessment, individuals are unable to apply for the temporary disability grants. Also, another question asked by the member, they wanted to know how SASSA would verify if an applicant received financial assistance from their family, and would this application be disqualified? And also if additional staff would be appointed to monitor this discrepancy. Also, they wanted to know whether the department has planned to accommodate other 2.9 million unemployed people, as the SRD grant allocation only covers 10.5 million of the 13.4 million unemployed persons. They also wanted to know about the school going 18 years who are currently receiving SRD grant, and also they wanted to know what plans were in place to ensure that the mental illness such as schizophrenia, yes, classified as permanent disability. They also suggested that in the next meeting, the department should allow it to interface with its online application platforms. Chair, there's a lot of issues raised by the members, and I hope that the members went through the minutes to verify what has been produced or drafted is what they just deliberated on. Instead, it's a 9-page minutes, Chair, and then there were a number of responses provided by SASSA and the department, Chair. And then I think the most importantly are the resolutions. The committee requested that the minister submit a progress report on the implementation of SRD grants, and also to receive the terms of the agreement between SAPO and SASSA regarding the disbursement of all other social grants, excluding SRD. Our member Abraham said some of her questions will be sent to the department in writing regarding the child support grant top-up. The department arranged to take the members through an interface on the online application system for SRD grants to assess its user-friendliness. Currently, SASSA is reviewing its agreement with SAPO to disburse grants, and once completed, SASSA will provide the committee with an update. SASSA asked the committee to provide in writing the cases of individuals who have not received their SRD grants. The meeting adjourned on this day at 12 o'clock. Thank you very much, Chair. Chair.
Okay, can I yes?
Over to you.
Thank you very much, Lindy. I see the hand of Honorable Sugers and Honorable Jane.
Yes, Chair. Shall I proceed?
Proceed.
I want to just make a correction. I was present in the meeting. I left early. The apology was that I had another meeting that I needed to attend to. So I could only be there for the first portion of the meeting and then had to leave. Thank you.
Thank you, Honorable. Honorable Jane.
Thank you, Chair. I was there when you opened and the minister and the CEO of SASSA. I left when the question were asked because I was at the doctor. Thank you.
Okay, thank you, honorable members. So I think Lindy has taken note of those things. Then can I get the hand to adopt the minute with amendments? No one to adopt?
I'm here, Chair. Thanks. I move for the.
Oh, Honorable Mhlongo, sorry. Honorable Mhlongo.
Thank you, Chair. I move for the adoption of the minutes.
Thank you, Honorable Mhlongo. Any seconder, honorable members? Should I second by myself? Which I can do because I was present.
Your chair, you only use your vote when there's a tie. We can just allow other members.
I know, I'm teasing them because I don't see any hands for now. So these minutes are not seconded. How
Yes,
do you
Chair, I cannot second because I didn't finish the meeting. Thanks.
Okay. Honorable Stock.
Thank you very much, Honorable Chairperson. I second the proposal to adopt the minutes as a true reflection. Thank you very much.
Thank you very much, Honorable Stock. Can we then, is there any other item, Lindy?
No, Chair, we'll conclude the
Is it the close?
Yes, Chair.
Thank
Yeah,
you very much.
in your hands.
Thank you very much, honorable members. It was not easy. I don't even want to say after 8 years, as Honorable Masango has made mention of the years, which are quite a long years, really. These things are not familiar. I hope that at least this will stop as of now and not happen, but people are really free to discuss and deliberate on whatever time they are given time to speak. Thanks ever so much. The meeting has adjourned. We'll meet on Friday. Thanks.
Thank you, Chair.
Yes,
Thank you, Chair.
You chair these types of meetings.
I'm going to end the meeting for everyone.